to my knowledge, additional
maybe this place is close because my leader is sitting there. My leader is sitting there. So the leader is around. Yes.
Good morning, ladies and gentlemen. Please let's rise for the national anthem. And to lead us in that is Lawrence Lloyd Benson.
Rise, O compatriots, Nigeria's all obey, to serve our fatherland with love and strength and faith. The name of our heroes past shall never be in vain. To serve with heart and might, one nation bound in freedom, peace and unity.
Thank you very much, Lawrence. Please can we give him a round of applause? Honorable Minister of Finance, Budget and National Planning, ably represented by Ajia Fatima Ayatu. You're welcome. Honorable Anthony General of the Federation and Minister for Justice. The Executive Chairman, Federal Inland Revenue Service, Muhammad Nami, ably represented by ML Abubakar, the coordinating the Permanent Secretary, Federal Ministry of Finance, Aliyu Ahmed, ably represented by Mr. Abdullahi Attar. Sorry about that. The chairman of the FCTIRS, the chairman of the FCTIRS, Mr. Abdullahi Attar. And we also have the representative of the Attorney General of the Federation and Minister for Justice, Dr. Abiodun. You're welcome, sir. We also have the representative of the President of the Nigerian Bar Association, Mr. Olumide Apata, and his representative is Dr. Jude Odinkodibo. You're welcome, sir. distinguished chairman and honorary commissioners. We also have the president of the Chartered Institute of Taxation of Nigeria, Dame Gladys Simplis. You're welcome. Ladies and gentlemen, you're welcome to the Tax Appeal Tribunal Retreat 2021. Let me kickstart the program by inviting the coordinating secretary of the Tax Appeal Tribunal, Mrs. Olanle Oniyogi, for the welcome address.
Good morning, the Honorable Minister of Finance, Budget and National Planning, ably represented by Ajia Fatima Ayatu, the Director of Finance, Federal Ministry of Finance, the representative of Attorney General of the Federation, Dr. Abiodun, the representative of Executive Chairman, Federal Inland Revenue Service, Alhaji ML Abubakar, Coordinating Secretary, Office of the Executive Chairman, Coordinating Director, Office of the Executive Chairman, Federal Inland Revenue Service, the representative of the President of Nigerian Bar Association, Dr. Jude, the chairman of FCCIRS, Alhaji Abdullahi Hassan, the president of Chartered Institute of Taxation, Dame Gladys Simplis, the chairman and honorable commissioners of Tax Appeal Tribunal, the coordinating directors of the Federal Inland Revenue Service here present, the secretaries of the Joint Task Board, other invited guests, distinguished ladies and gentlemen. I welcome you all to the retreat with the team of the Tribunal in Changing Times. The objective of this retreat is to enhance the capacity of TAT to effectively discharge its statutory mandate in the light of the new national and global realities, as well as to improve the knowledge of the commissioners and staff in key areas of the taxation. I sincerely like to thank the Honorable Minister of Finance, the permanent Ministry of Finance, Budget and National Planning, the permanent Secretary, the Director of Technical, Ministry of Finance, and other principal officers of the Federal Ministry of Finance for their tremendous support towards the smooth operation. I also wish to say that I remain grateful to the Executive Chairman, Federal Inland Revenue Service, Mohammed Mama Nami, for his immeasurable and continuous support, for the continuous and immeasurable support in ensuring that the operations of the Tax Appeal Tribunal are well funded. I sincerely express my gratitude. It is also important for me to appreciate the efforts of the various chairmen and commissioners who have shown total commitment and dedication to the duty and the various rooms of the tribunals. They are all appreciated. The tribunal has taken various initiatives and strategic steps to reposition the tribunal and improve its operational performance. The initiatives are expected to drive the performance of the tribunal and improve the timeline for resolution of disputes, which will consequently engender taxpayer confidence and improve voluntary compliance. The tribunal within the last year has, despite the COVID pandemic, has achieved a modest achievement in the resolution of disputes that came up before the various zones of the tribunal. The tribunal has resolved about 79 cases with approximated tax disputes over 104 billion naira, 700 million, and $84 million, 692,000 in the period of January to December last year. New appeals filed within January to December last year were approximately 72, with a total value of about 33 billion, 456 million, 171,807 naira 52 kobo, and $361, $61,000, $321,341 naira 7 kobo. The tribunal has embarked on innovative, which include a cloud-based file sharing and staff collaboration portal, which enables staff to work remotely from various zones of the tribunal. This has enhances the remote transcription of digital recording of the proceedings and facilitates the time for transcriptions of the proceedings of the tribunal. In this initiative, the transcription of the tribunal can be done from anywhere apart from the zones where the tribunal sits. Also, as part of the initiative of the tax appeal tribunal, we have required some taxpayers who have cases before the tribunal who want to settle the matter of the tribunal to exhaust that opportunity with tax authorities. And quite a number of cases have been resolved in that one. About 6 cases were finalized through this process between the period of January to December last year, with a figure of over 400 million naira, which were already settled by the taxpayer with various tax authorities. We have some still pending on the table of the tribunal's resolutions, and hopefully within the coming weeks we will be able to sort this out. Also, we have a tax advisory committee which reviews some of the cases of the TAC cases. The tax advisory committee have in the past 1 year been able to review about 10 cases pending within the various zones of the tribunal, and also did a holistic review on the Stamp Duty Act, enactment bill 2020. The committee also creates recommendation to the Minister of Finance for the Bachelor apparatus during the sittings, and this was captured during the 2020 finance acts. We are most grateful for this innovative that was introduced to the tribunal, and we have since embraced this model approach. The tribunal has, in this wise, called for operators to enable us to develop a software to be deployed in virtual setting and virtual private tribunal business. The process of installing the software to its ground running. And even then, we have started filing some processes online, making service of processes online, collecting the soft copy of the proceedings so that the chairman will not be able to writing everything, since the technology is the in thing now. We have also embarked on quite a number of provision of infrastructures in various zones of the tribunal to make the work of the chairman and commissioners seamlessly. Not only that, within the year 2021, the first quarter, the tribunal has performed very well during the first quarter of 2021. As at January to March 2021, the concluded cases in the legal zone is about 9. And we have about 71 cases pending. South we have concluded 2 matters in Ibadan. We have concluded 3 matters in South, we need 3 matters. In Kaduna, we have concluded 5 matters, and in Bauchi, 1 matter concluded. This is outside some matters that are tested down for settlements out of the tribunal. And I want to bring it to your notice that even some matters that come before the tribunal, as soon as the non-compliance starts by a player, since that the writing on the wall, they quickly go ahead and pay the appropriate taxes. So the tax authority starts going through. This I will not be able to figures of the various tax disputes, but I can assure you they are quite a huge amount, which if we realize contributes to the nation building of our nation. Apart from all these achievements, the tribunal is not without some challenges. The COVID-19 pandemic and the surveillance challenges have negatively affected the operations of the tribunal and slowed down the implementation of the work plan. Not only that, we have processes of appeal in most zones of the tribunal, which is not only related to COVID-19, slowdown of business activity in Nigeria and all over the world. We have also identified conflicts, observed that there are some conflicts in some states' revenue, which has provided for another dispute resolution mechanism for tax disputes outside the tax appeals tribunal. Also, the limited powers binding the THC in the enforcement of the decision as an administrative tribunal is one of the issues that hinders the THC from enforcing its judgment. This is we are appealing to the Ministry of Finance and the executive to give us the tribunal the full autonomy. The tribunal will be able to run on its own without being an appendage of any institution. We also appeal for a permanent structure which will enable us to save a lot of costs in the payment of rents annually. I thank you all, and my fervent belief and desire that these streets will help us to improve ourselves, to embrace technology, and deliver quality and efficient tax execution service in this new environment. You are welcome for the most useful for us.
Thank you very much, Mrs. Bonale Onyami. Please, I'd like to clarify that Ajia Fatima Ayato, she's here in double capacity. She's representing the Honorable Minister of Finance, Budget and National Planning, and also the Permanent Secretary of the Ministry. Please, may I invite her forward for the special remark on behalf of the permanent secretary. Welcome, ma'am.
Morning, members of the country. Good morning, distinguished chairman and committee commission. I want to express the apology of the Minister of Finance, Budget and National Planning for her inability to be here today. She would have wished to be here personally, but due to some circumstances, she was called to be that. The permanent secretary assured me as of last night that we are coming to this occasion together. Unfortunately, they had a board meeting, an emergency board meeting with the CBN, so we had to go there too. So to tender their apologies. It's the permanent secretary's remarks. To instance, I'll just look at the protocols that we observed. It's my privilege honor to welcome you all to the two-day retreat, which I understand has its objective towards collectively setting strategic action plans in capacity building for the tax appeal commissioner for effective and efficient tax administration. Let me start by sincerely thanking the Honorable Minister of Finance, Budget and National Planning, Mrs. Dr. Zainab Shamshuna, for being supportive to encouraging successful and concerted actions towards ensuring effective tax tribunal functions within the context of the fifth schedule of the FIRS Establishment Act 2007. The tribunal is one of the windows provided in Nigeria's tax administration system, which offers an aggrieved party the opportunity to explore other dispute resolutions mechanisms before gaining access to lawsuits, to the law court, Amongst other things, it helps reduce the case load of the overburdened regular courts by providing an avenue for quicker, cheaper, and expert resolutions of the disputes in public interest. With the background, deliberations during this retreat should be anchored. With this background, the deliberations during this retreat should be anchored in helping to solve all the disputes at the TAT's core mandate arising from the operations of extant tax laws and regulations. The retreat we did, this retreat we did tax appeal in terms of change is very apt, especially in the area of or wanting government at the appropriate time render assistance to enable smooth delivery of the set objectives of the tribunal. An example is where the government, on its desire to strengthen the operations of the TAT, took some strategic measures, including the issuance of the tax appeal tribunal proceedings 2010, which applies to all proceedings before the tribunal and ensures compliance with standard procedural practice. In a nutshell, this retreat should be used as a stock-taking exercise where all activities of the TAT from commencement shall be laid bare with a view to identifying gains, gaps, and challenges to strengthen its operations, especially against the backdrop of the global pandemic and the current realities at home. Finally, I wish to congratulate the conveners of this session, the TAT Secretary, Roland, you've done very well. And also to deliver on the vision of the tribunal, which is to be a leading tax dispute resolution center of international repute worthy of public trust and confidence. I thank you once more and wish you a fruitful deliberation and a successful retreat. Thank you.
Thank you very much, ma'am. I would like to move on to the keynotes. Sorry. The good reading messages by the stakeholders. The first on the list is the president of NASIMA, and he'll be represented by Barrister Chukwuemeka Eze. Please, will you come forward?
Good morning, all. Good morning, high table. Good morning, colleagues. Good morning, the fourth estate of Iran. I humbly seek to be allowed to stand to follow the protocol so as not to waste our time. This is the goodwill message of Ajia Saratu Ali, the National President of the National Association of Chambers of Commerce, Mines and Agriculture, the Honorable Minister of Finance, Budget and National Planning, Ajia Zainab Ahmed, the Permanent Secretary, Alhaji Ali Ahmed, the Executive Chairman of Paris, the Coordinating Secretary, Tax Appeal Tribunal, Ajabola Niyongi, Honorable Chairman and Commissioners of the Tax Appeal Tribunal, paper present as members of the Fourth Estate of the Realm, ladies and gentlemen. It is my pleasure to be invited to this important occasion. I commend the organizers of this program for considering the organized private sector as represented by NASIMA as a veritable stakeholder in tax matters. Involvement of the private sector in engagements of this nature accords with global best practices. NASIMA at its council meeting in Port Harcourt in November 2020 had called on the government at all levels to increase their engagement with NASIMA in order to enhance program implementation of the government. We appreciate the federal government for beginning to heed the admonition. For the records, the principal objectives of NASIMA are ensuring the creation of a conducive atmosphere for the pursuit of commerce, industry, and all other forms of economic activities of interest to the private sector, the promotion, protection, and development of all matters affecting businesses, contribution of ideas for the overall economic stability of the nation, encouragement and promotion of the nation's private sector, provision of a network for national and international business contacts and opportunities. The survival of the private sector is hinged on the fiscal and monetary policies of government of the day. We acknowledge the role of taxation as an instrument of economic development in our country, including Nigeria. Our patriotic members have been paying their taxes regularly, without which it would have been difficult to meet the government's obligations to the people. Recently, NASIMA wrote to the Joint Tax Board requesting for collaboration in order to improve tax compliance. Our members have, however, tales of the various unsatisfactory enforcement strategies adopted by some revenue authorities to maximize revenue generation. Sometimes businesses are sealed for phantom tax liabilities and without prior adequate notice. The multiplicity of taxes and levies and the interpretation of tax laws to generate revenue at all costs have become worrisome to our members. There are reports that the implement fiscal regime has forced many investments to exit Nigeria and proceed to some other West African countries. We appeal that tax authorities should administer tax laws with a human face. This is because aggressive tax drive will drive away investment. and leave our economy prostrate. The private sector is the goose that lays the golden eggs. Hence, their interest should be paramount in policy formulation and execution. As you continue your deliberations, I wish you God's abundant guidance for the good of our country. Ajia Saratu Ali, National President, Nasima. Thank you so much.
Thank you very much, sir. I think the next goodwill message is the representative of the executive chairman of the Federal Inland Revenue Service. And I should end up.
Good morning. I was wondering why Mr. Esse was not on the IC because he's wearing 3 caps. The chairman as a commissioner and as a member representing Nasima. The Honorable Minister of Finance ably represented by the Director of Technical in the Ministry, the representative of or the President of the CITN, the Executive Chairman FCT IRS, my colleague, Coordinating Director, Compliance Support Group, Mr. Dick Iri, the representative of President of NBA, the representative of the Attorney General of the Federation, the distinguished commissioner, paper presenters, and ladies and gentlemen. The Executive Chairman of the Federal Revenue Service, Mr. Muhammad is unavailably absent, was sending his apology, and has also directed me to his good message. But before then, let me share an experience of the two. At the policy call yesterday, members of the commissioner had policy call on the EC at Revenue House yesterday, and with the introduction of the delegation, professors, directors, baristas, and the chairman said he was not intimidated. Today, I'm also representing here, and I'm not also intimidated. But there's a special reason for that. I'm supported here by Mr. Iri, who has defended his PhD thesis. I will soon confer with PhD degree. It is my pleasure to be present at the opening ceremony of this retreat organized for the commissioners of TAT. The event is my first opportunity of meeting the TAT commissioners since assumption of my office as executive chairman of FRS and chairman Joint Task Force. May I therefore use this medium to express my appreciation to you for your contribution to the growth and development of our tax system through your erudite interpretation of the tax laws. The retreat is coming at a time when concerted effort of stakeholders in the tax administration are required to raise revenue profile of the government. The TAT is a major stakeholder whose mandate and activity contribute to the growth of tax administration system. Hence, a retreat of this nature is most desirable. As we are aware, Dispute resolution mechanism is an integral part of any tax system. And in Nigeria, the law provides a multi-layer mechanism for resolution of any dispute that may arise from administration of tax laws. The Tax Appeal Tribunal, being the first external window for the resolution of any tax dispute, is crucial in determining the efficiency, effectiveness, and transparency of the tax dispute process. Your decision and judgment form the basis upon which an aggrieved party will further appeal to the Federal High Court, the Court of Appeal, the Supreme Court, as the case may be. This means that the quality of your decision must be very high, reliable, and devoid of ambiguity in order to stand the test of future legal argument at the court. I therefore encourage you to ensure that your judgments are backed by strong, well-grounded principle of law, taxation, and facts. It is also important to draw your attention to one of the crucial activities of the establishment of TAT, which is to promote early and speedy resolution of tax disputes and less reliance on legal technicalities. Accordingly, there is an urgent need to facilitate the timeline for determination of appeal, as a long appeal cycle time hinders the timely collection of taxes due. Moreover, the aim for a speedy resolution is defeated if non-compliant taxpayer finds a haven in the tax due to delays and long adjudication process. This we should guard against by coming up with innovative ways to minimize the delays. I recommend that the TAT should consider amending its procedural rules to provide for an accelerated hearing, adoption of alternative dispute resolution for non-contentious issues, and provide a timeline for resolution of any appeal brought before it. Following the amendment of the relevant section of the FRS Establishment Act 2007 and in the 2020 Finance Act to allow for virtual sittings by the TAT, may I use this opportunity to call on the commissioners to embrace technology. This has become very pertinent if members and tribunal must deliver on its mandates and remain relevant in this information and knowledge age. Another area that requires your attention is the need to ensure uniform interpretation of tax laws and avoid conflicting judgment on issues that have similar facts. Judgment of the tribunal on similar facts, irrespective of the zone for where it emanates, should be consistent, except where otherwise. This is why this is very important for reliability, integrity, and public confidence in the tribunal. Therefore, there should be more collaboration and timely circulation of judgments and decision and results. The public expectation is that the tribunal will discharge its function based on equity parties and be very fair. This will go a long way in engendering public trust and confidence in the tax system. I therefore enjoin you to continue to carry out your duties in line with the cardinal objective for which the tribunal was established, and to ensure that justice is done quickly in order to deepen the tax jurisprudence in Nigeria. On this note, I assure you that FRS, being a partner and major stakeholder of TAT, will continue to support the tribunal without interference and undermining its independence. We shall continue to respect the decision and judgment of the tribunal where dissatisfied, we will explore the window provided by law for further appeal. I commend the organizers of this retreat and hope that the expected cross-fertilization of ideas in the course of the discussion will boost the capacity of the commissioners and enhance the performance of the tribunal in dispensation of justice and enrichment of the Nigerian tax system. Thank you very much.
Thank you very much, sir. To take us in the next goodwill message is the representative of the Honorable Attorney General of the Federation and Minister for Justice. That's Mr. Abiodun Ayodeji. I call. Yes.
The Honorable Minister of Finance and National Planning, ably represented by the Permanent Secretary, the Coordinating Secretary of the Tax Appeal Tribunal, ladies and gentlemen, please permit me to stand on the existing protocol. The MC had introduced me earlier as a doctor, and I was just smiling and smiling. Apologies to the PhD holders in the house. PhD is a crazy degree that I don't want to do. It's a crazy degree. I bring greetings from the Honorable Attorney General of the Federation and Minister of Justice, Mr. Bakar, who is unavoidably absent. Who is unavoidably absent? We have loved to get, but he sent regards to everybody. In delivering this goodwill, these remarks on behalf of the Attorney General, please permit me to read from the Gospel according to St. Matthew, chapter 22, verses 15 to 22. Then went the Pharisees and took counsel that they might entangle him in his talk. And they sent out unto him their disciples with the road, saying, Master, we know that thou art true and teachest the way of God in truth. Neither carest thou for any man, for thou regardest not the person of men. Tell us therefore, what thinkest thou? Is it lawful to give tribute to Caesar or not? But Jesus perceived their wickedness and said, Why tempt ye me, ye hypocrites? Show me the tribute money. And they brought in a penny, and he said unto them, Whose image and superscription is on it? They say unto him, Caesar's. Then saith he unto them, Render therefore unto Caesar the things which are Caesar's, and unto God the things that are God's. When they heard these words, they marveled and left him and went away. From time immemorial, taxation has been a problem for men. People always want to avoid paying taxes. Unfortunately, the more people earn or the richer they are, the difficult it is to pay taxes. So, but unfortunately, the Pharisees were looking for a way out so that they will not be paying taxes. That's why they went to Jesus. And he told them, pay unto Caesar what is Caesar's. That is the foundation. In our constitution too, under section 24, subsection F, it is a duty for every citizen to pay taxes. So whether we like it or not, laws, taxes are compulsory, taxes are laws. So the work of the Tax Appeal Tribunal is very, very important and critical. Just as it has been from the beginning, so it is today. So Tax Appeal Tribunal, we recognize that you are doing a very difficult job in any society. And in the context of that, having this type of deliberation and conference is very important. Because from the theme, Tax Appeal Tribunal is changing times. Things are changing. COVID has shown us that we cannot afford to be rigid. We cannot afford the way we have always done it. Times are changing. We coupled with the work that we do, that people do not ordinarily want to pay taxes, and they will look for ways after tax planning to even evade. So your work is, like I said, recognized
as a very tough job, and this kind of conference is very important. So we, on behalf of the Attorney General and the Ministry of Justice, we know that taxes are laws. We know that laws are required to achieve the reforms that you may desire to make your work better. So the Attorney General sends his support and assurance that after stakeholders have deliberated here, any reform that is required, as far as law is concerned, to make your work easier, to make your work better, to embrace the current disruptions within the context of the law, the Attorney General will give all the support that is required. Our tax ratio in Nigeria is less than 7%. The average in developed societies is about 33%. So we have a long way to go. And this is a time when we need revenue from taxes more than before. So at this time, once again, we wish you well in your deliberations as we await your recommendations and communicate so that we can improve it and improve our tax administration in Nigeria. Thank you so much.
The correction has been voted. It appears that we are running out of time and want to be as swift as possible. So for the next goodwill messages, we'll be taking just 2 minutes, please. I'd like to recognize the presence of the Joint Tax Board Secretary, Mrs. Nana Aisha Abumeli. The next goodwill message will be by the President of the Chartered Institute of Taxation of Nigeria, Dame Gladys Olajumoke Simplis. You're very welcome.
Thank you very much. Good morning, everybody. I would like to crave your indulgence to respect the already established protocol, because I don't know the people I'm supposed to recognize, but because we are all somehow lavajas. I want to congratulate the FIRS because we've come a long way from what of our big commissioners. Here we are. And we've had a report from the IGR Ominagi. A lot has been done. And that is what we are asking for in this country. Let us build institutions. TAT is becoming an institution of record. And that is the way it should be. Taxpayers are building confidence. It's in line with the vision of TAT, which says to be a dynamic tax dispute resolution center worthy of public trust and confidence. And that is what is happening. Taxpayers are already building confidence and are big tribunals. What is the tax? It has to be just. If you're asking me to pay what I don't believe I should pay, I have the right to take you to court. So Tax Appeal Tribunal, I want to appreciate you. And I've heard a lot of taxpayers talk about how they have gone to Tax Appeal Tribunal and how they have succeeded. And this is the way to go. Practitioners, encourage your clients to go to court when they are aggrieved. Tax Appeal Tribunal, I have read some of the judgments, and you see what it has also done is to put revenue officers on their toes. You cannot just take actions without recourse to law. What does the law say? It must be final and conclusive. Did you follow the process? Things. So it is also good that when decisions are taken, revenue officers are put on their toes. They have to learn. They have to know. They have to follow due process. They have to follow the laws. Tax Appeal Tribunal, thank you very much for landmark decisions that you have made. Even where revenue officers have been put to shame, it is very good. Let it continue. Just like the revenue offices are also building institutions, building capacities. Let us all build capacities. In building capacities, statutory organization is building capacity. We have that pathfinder, we have the structure to build capacities for taxation. And I want to appeal to lawyers here. There is a gap, knowledge gap. If you are not a member of CITN, you have that knowledge gap. You have to be a member of CITN, build capacity in matters of taxation, build capacity. It is very, very important. Especially now that taxation is global, we go global. Let me tell you what is happening in the field of taxation internationally. Lawyers here. The issue we are talking about in the international laws in Vienna, I was a panelist in one of the discourse, is client attorney protection. Client attorney protection, client attorney privileges. These are the issues that are on now. Very interesting. I never knew about it until I was asked to be a panelist. I had to do some research. And it is not developed in Nigeria. Lawyers, these are the issues. Build capacities in taxation, both locally and internationally. Thank you very much. Capacity building, Tax Appeal Tribunal, build capacity for your members. Continue the good work that you are doing. God bless you all. Thank you.
Thank you very much, ma'am. May I invite Dr. Jude Odi-Konigu, the representative of the President of the Nigerian Bar Association. Welcome, sir.
Good morning, everyone. The representative of the minister, the representative of the chairman of the FIRS, my chairman of the CITM, and everyone here. He rightly pointed out I'm here to represent our president, the president of the NBA, Mr. Olumide Apata, my boss. I'm a council campus and also a senior lecturer at University of Nigeria campus, where I have taught different aspects of taxation for more than 10 years. Drawing on this, everybody knows, and we have all agreed that the role of Tax Appeal Tribunal, the administration of tax disputes in Nigeria, is very, very important. Even from our research, we've seen that a lot of issues have not been streamlined in the past, that the present TAT and the past one have tried to do a lot. For instance, the definition of fixed pays under section 13, subsection 2, which the multinational oil companies, IOCs, have been using to defraud the federal government of Nigeria billions of naira. You all know about the case of Shell, Master Beach, and the FBI, where the definition of fixed pays was, even though it was held that there was fixed pay, interpreting that provision of CETA, but it wasn't defined until another case where the Tax Appeal Tribunal came to define that as anywhere you hold as an office or where you use as a place, because in that case, what Shell was doing, that they coming to Nigeria and use the subsidiary Nigerian Shell without having any particular place. So as to say, I don't have a fixed place, therefore I shouldn't be taxed. So that is technical tax avoidance situation. And TAT has come to say, wherever you use, that becomes your fixed place. So, Tax Appeal Tribunal, we're very happy. You know, the members, most of all the chairmen all the chairmen there, all lawyers and members of the bar, which all of us belong. I can tell you that they're very, very proactive in the way they handle matters. And no two ways about that. So a lot of developments, we've had a lot of legal developments in the law, even this issue of reverse charge before the Finance Act 2009 came. From TAT down to the Court of Appeal, I think in the case of Onyo's case, it was decided in that case. Now, I listened to Alaja Bolanre Hajara Omiyangi. She said that one of their problems is the issues of enforcement. We want to be autonomous. I heard her say that. Because you know that following the provisions of the Finance Act, following the provisions of the Federal Revenue Service Act 2007, that appeals emanating from TAT goes to the High Court. And some people ask questions. If you look at the chairmen of all this, they are sound men. Most of them 15 years to score, most of them 20. And you also have accountants. You have professionals that critically look at this. And the appeal will now go to a single judge. And what it means to be a judge is just staying in score. I think the problem was because government wanted to solve the problem that was created in the case of Vistanini Vasolini and FBI. Where the Court of Appeal, when it struck out Section 20 of the VAT, saying that it conflicts with Section 251 of the Constitution. We tried to avoid that. And again, in all the cases that we've seen, gone at a point, both federal and the one I'm going to be giving conflicting decisions about the status of TAT, until it gets to the Court of Appeal, and the Court of Appeal has to decide that actually TAT is an administrative tribunal. It is an administrative tribunal, it is not a court. Now, how do you solve this issue? We propose, if you go to Canada, they have tax court. You go to America, they have tax court. Why can't we replicate that here? Because these men who are handling the tax appeal trial, to which we will build our tax court here. And building that, making the tax court a superior court of jurisdiction under Section 6 of the Constitution of the Federal Republic. The same thing that was done for the National Industrial Court through Section 254C. The Attorney General representative is here. Please take this message to the Attorney General. It's very important. That is the best way, that is the right way to go. Without taking much of your time, I have a lot of things to say. I have to thank everybody here. Thank you so much.
Thank you, sir. Thank you very much. And for the final message, we have in our midst the president of Association of National Accountants, Anna, ably represented by First President Dr. Menene. Please. Ladies and gentlemen, we are very sorry. The representative of the Honorary Minister of Finance, Budget and National Planning is about to leave, and she would like to declare the retreat open. Please, behind the
I just the Honorable Minister of Budget and National Planning. I wish you well and urge you all to do your best in mission building and improving revenues for government. We charge.
Tax Appeal Tribunal, we'd like to present the Honorable Minister of Finance with an award to recognize and appreciate their contribution to the success of this program. In this regard, may I have the privilege of calling on the President of CITN, the day, there's only one day in this morning, and that's our day. May I invite Dave to respectfully give the award to the Honorable Minister of Finance on behalf of Tax Appeal Tribunal. I think it's better for us the photographers can have it. Thank you.
Yes, yes. Thank you very much for giving me this privilege to present this. Ministry of Finance is my primary constituency. We appreciate what you are doing. Please give our warmest regards to the minister. Thank you very much.
Not yet, man, not yet. We have an award for the permanent secretary in the Ministry of Finance. And I understand Madam will also kind of accept this.
I would like to also inform you all that Ajia Fatima Ania is also a member of Council of the Institute of Taxation of Nigeria.
And finally, Ajia has been wearing 3 caps since morning. She is representing the Honorable Minister of Finance, she's representing our Permanent Secretary, and now she's going to accept this award on her own behalf. Thank you.
I'll continue. That Ajia is very, very, very technically sounded. A very technical person in the Ministry of Finance. You don't joke with her. She's very technical. She's the Director of Technical, Ministry of Finance.
Thank you very much. Thank you. Well, yes, thank you very much. We have one last award here for the chairman of Federal Inland Revenue Service. And Madam, before you go back, one good on deserves another. May I respectfully call on you to present this award to the representative of the chairman of Federal Inland Revenue. We are more than grateful.
For the support of FRS towards the successful work of the TAT. That would be TAT. I present this award to you for the chairman, the executive chairman of FRS, and to express our gratitude.
Thank you very much. Thank you. Okay. Can we have a good photograph of the distinguished ladies and gentlemen on their team? Thank you very much. Okay. Better be good, guys. Photographers. Okay.
Yeah, good morning, ladies and gentlemen. I just requested to be allowed to make just an announcement or a request of this honorable appeal tribunal from what the representative of the chairman of FRS said and the North Central Zone that visited me. I know that the tax appeal tribunal is made of very, very honorable and very, very dedicated people. So I have an issue that I have said here the last time you have an appeal. FCTRS, because we just copy and paste, we have there in our art that we have a tax appeal tribunal, and that has been an issue for me. It's been an issue because we have 165 consultants now auditing over 900 MDAs and hundreds of companies. And I expect there will be a lot of appeals, a lot of complaints. Where do I go to? And I've seen it, I've discussed with your representative from the North Central. I'm not satisfied with what they told me. So I want to again lay it to this group to please help me deliberate and help me out of it, because very soon I will have issues. And one of those issues, because I'm already seeing signs of it. When the representative in the North Central we met, they told me that the tax appeal tribunal of the Federation is superior. But when I spoke with some of other lawyers, they told me that is not the interpretation. To your lawyers here, you will help me interpret it, because our act is the last. I should stop. Okay, so thank you. So I have this situation that I have to leave because I'm going for a meeting. I have two other events that I have to be at, and I felt that once I have this opportunity, I should lay my case to this honorable house. I believe with all the professors in the house, with all the experts in the house, they will help me solve my problem. And what I was telling you is, after discussing you are not central representative here, and they said that of the federal is superior, but after discussing with some other lawyers, they told me too, our own act was made by the National Assembly. So, because we're also made by the National Assembly, and it is in letters in time, that there could be conflict. Now, and we're going to be talking about taxpayers. If we take them to court and we come to a tribunal, they could decide question of you have no jurisdiction or whatever. So please, I want this house to help me. I've invited my director legal to come and sit with you people for the 2 days, find time to discuss this most important issue. Be at the heart of the federal republic and the type of taxpayers we have, Mr. President and members of the National Assembly and all the powerful people. And very soon we'll be going to court with some of them. Because if you don't pay your tax, they will want you to court. And where do we go to? So please help me. Thank you very much.
Thanks, sir. Before you take your seat, sir, I have a small assignment for you on behalf of TAT. TAT recognize and appreciate the pioneer coordinating secretaries. They are the people who build the foundation that we are enjoying today. So please, we want to present some awards of their secretaries. Thank you very much. No, you are not going to present the award to them. Oh, you want me to present? Thank you very much. Okay. May I have the honor of calling to the podium Madam Yaya M. Abubakar. Let's put our hands together for the pioneer and secretary. Well, I don't know what to say.
I wasn't the coordinating secretary, but I was the pioneer coordinating director and special advisor to IFECO, and all of these people were appointed in my time in FRS. So yeah, I can see that you have put a belly. You've done such a good work. So on behalf of the tax administration, we are recognizing you wherever you are in FRS. I'm sure you continue to fly. Thank you very much. Okay, like I said, for a lot of you don't know, I am FRS. I think I'm still FRS, and I've always told FRS I want 117 of their staff working with me. So of all the state chairman, I'm the only one that is a chairman in FCT and probably a director in FRS, because I have 117 staff. And ML was my good friend in FRS, and he's done quite a good job in JTB and tax appeal tribunal. So sure.
Thank you very much, ladies and gentlemen. Please, the chairman of the FCT-IRS has raised a very valid point and questions, and it calls for some response. So Dr. Mr. Eze Chukwuemeka has said he would respond to it. Please, sir. Chairman, sir. Dr.
Sorry, the speaker here is in love with doctor. But I'm Mr. I'm still doing my PhD in international taxation. So thank you for raising this issue before us. Before you leave, we are going to give you a research on the Constitution.
I'm sorry, we are not we are one family, just like the FCC chairman has said. FCC chairman is part of the revenue authority. I think this is an in-house matter that we should not join issue of the president. So we are angry with the family. Thank you very much.
Please, I would like to invite the president of the Association of National Accountants, represented by first Vice President, Dr. Mininebo, for the presentation.
The Honorable Minister, here represented, people doing abstention, very respected members of the right table, chairmen and commissioners, ladies and gentlemen. My name is Dr. James Nemi. I'm the first Vice President of the Association of National Accountants of Nigeria. I am here representing my president, the president of ANA, Professor Benjamin Chuka Osisioma, the brand new president that was elected on Saturday. He would have not been here today to be with us. Incidentally, because of our new university, he was called for a meeting in Jos. So he went with the team this morning. He really would have been here. He asked me to bring his love to you, and he really would have had time to interact with all of us here. That we professionals, we have taken pains to build capacity of professionals. And that when we build capacities, we know our people are up to coming to work for a robust financial economy. And FIRS and all its team, they are working very hard to build the financials of this country. And we know that these persons for whom we are building capacity are coming to work in a situation where finance will not be a challenge. TAT, we look up to you. We have heard so much this morning that because of you, our economy will be robust. We trust you and we hope to build more capacity to assist you grow the economy. Thank you.
Thank you very much, sir. Please, we have in our presence the representative of the ICANN president. Representative of the ICANN president, Alaji Tijani Isa. Welcome, sir.
Assalamu alaikum warahmatullahi wabarakatuh. Ramadan Kareem. I'm here standing wearing two caps. One is a commissioner in the Northeast Zone, and secondly, the president of ICANN, Dame Onome Joy, asked me to represent her in this meeting. I came in late, not deliberately. We had 2 meetings. We are taking two now. We have so many ICANN members who are commissioners, and the council is going on. Council meeting started for 11, but before then, we had a meeting for 10 o'clock. We called the ACC before the council meeting. So that's why I came in a bit late. My good news message is just to wish us luck, and I believe Nigeria is under taxed, and there are so many challenges. We have both the challenges of the economy, we have the challenges in the development of the professions. We also have challenges of the tax resolution, the tax. I don't have to tell you that. And we pray that we'll do our best to make sure that to do that. We also pray that the recognized accountancy professions will produce quality products for input into the system so that we can get effective tax resolutions. That's what we say. And we pray that the economy improves because you need to generate the money. But the main challenge in tax administration has to do with both generation and collection. There are two different things. It's one thing is book paper, it's more paperwork generating taxation, but collection is something else. So we need, first of all, desensitization is important. Then provision of the enabling environment for the requisite number of tax practitioners with the requisite skill and experience to make sure that the overall financial objectives to do. But even that should be predicated on the national policy on taxation. In national, what is the position, what the significant, which is very, very significant, the position of the taxation as part of the national revenue profile. This is very important. So you have to look at it holistically. I wish us, I'm giving you this good news message on behalf of ICANN, the Institute of Chartered Accountants in Nigeria, and I wish us fruitful deliberations. Thank God and God bless. Thank you.
Thank you very much, sir. And we have the final award to be presented. I would like to present an award to Mr. Sani Dairo. Please come forward, sir. To present their award, please, the representative of Nigeria Bar Association President, please come from, please, sir. Present their award.
On behalf of the Tax Appeal Tribunal, to present this award in recognition of the way of contributions to the development of tax in this country.
Please, Mr. Felix Elele. Zero. It seems Mr. Felix Elele is not, he's around. You're welcome, sir. Please, may I invite the representative of the Attorney General of the Federation and Minister of Justice to present their awards.
On behalf of the Tax Appeal Tribunal, I hereby present this award in recognition of Mr. Felix Elele's excellent service to the Tax Appeal Tribunal.
Ladies and gentlemen, we are about to round up the first part, the part one of this retreat this morning. And to give us the vote of thanks is the chairman of the chairman of the Tax Appeal. Very pleased to welcome Mr. Eze Chukwuemeka for the vote of thanks.
Thanks.
Good day. This will escape. Says, okay. Welcome, sir. Thank you so much. The minister is gone, but we still extend our appreciation to the ministry. Without them, we wouldn't have been here. We are so grateful. Both the minister and the permanent secretary, we, the chairman and commissioners of the Tax Appeal Tribunal, quite appreciate what they have done in our lives, what they have done for the Tax Appeal Tribunal. We appreciate the Attorney General of the Federation, and we appreciate the comment made by his representative that whatever changes, including the communique we bring out of this retreat, should be sent to them and they will act on it. So we are very grateful. For the first time, we are receiving this type of promise. And permit me to call it an undertaking, such that Nigeria with its 200 million people, if we make the Tax Appeal Tribunal autonomous, Gambia, Sierra Leone, Ghana, they will be sending their tax experts here to come and understudy our own tribunal. Thank you so much, because the ministry will help in bringing this to pass. We quite appreciate the Federal Land Revenue Service. They have been, in a body you have the heart, you have the kidney, you have all parts of the body. Without them, the TAT would have been existing perhaps in skeleton. So we appreciate the Federal Land Revenue Service so much. They have not for once interfered with our work. I say this categorically. I have never, as a chairman of Southeast, received any instruction from the Federal Land Revenue Service to take a particular position in a case, or even a query to ask me why did I take it. And no other chairman has raised that issue that he had been directed one way or the other. So we are very grateful for the Land Revenue Service. Even though the perception by some people outside, they think you are holding us in your apron strings and you tell us what to do. But I'm saying categorically it is not so. Thank you for the independence you have granted us. We appreciate the Chartered Institute Organization of Nigeria. As we know, CITN is a member of the Joint Tax Board. And on the issue of taxation, it has been vested with the power to regulate and control taxation in all its ramifications in Nigeria. We are grateful for the relationship we have with CITN and for their promise to assist us in capacity building. We are grateful to CITN. The Nigerian Bar Association, thank you for honoring this invitation. We are grateful to you. Thank to the chairman that we are grateful for supplying all the chairmen and some members of the Tax Appeal Tribunal that are lawyers. And like you said, minimum of 15 years. Any chairman, no chairman is less than 15 years in the bar. So thank you for your suggestion to the authorities that they should make the Tax Appeal Tribunal a tax court. We are very, very grateful to you. We are also grateful to our coordinating secretary, who has, by her dint of hard work, integrity and faithfulness, brought us to this event today. We appreciate the Institute of Chartered Accountants of Nigeria, the Association of National Accountants of Nigeria. They are great stakeholders. The lawyers couldn't have succeeded in interpreting the laws without the accountants they have supplied in each of the panels. We are grateful to ICANN, we are grateful to Alan. Some of us are even illiterate on the issue of accountancy. So it takes two to tango. We are grateful for the marriage of the wisdom of lawyers and the wisdom of accountants. We are grateful to the executive secretary of the Joint Tax Board is here, Aisha Obomege. We are grateful for your attendance to this program. The Director of Oil and Gas of FIRS, Mr. Gabriel Ogunjemi, thank you. Dick Erie, Coordinating Director for Compliance of FIRS, and all others. It will be difficult to name everybody. Lastly, the fourth estate of the realm. We appreciate you for being represented. Thank you for the good work you are doing. Blessed be everyone. Go in peace. Our visitors. We are grateful. Thank you very much.
Thank you very much, sir. Please, may we rise for the closing national anthem.
O God of creation, direct our noble cause, guide our leaders right, help our youth the truth to know. In love and honesty to grow and living just and true. Great lofty heights are attained to build a nation where peace and justice shall reign.
Thank you very much, Lawrence. Now it's time for the group photograph. By the poolside, please. After the photograph, we can proceed for the tea break, but the photograph will be taken at the poolside. And to come back in 15 minutes time, please. Poolside for the photographs, tea break 15 minutes. Thank you very much for coming.
Okay.
indeed a rare privilege for me to have the opportunity to stand before you to share my thoughts on the changes that were introduced by the Finance Act of 2020. I do not pretend that I understand those changes better than most people in this room. And, you know, on my way to this place from the airport, I said to one of my friends who rode with me that it's not every time that we get an opportunity, you know, to make a presentation to people who judge your cases. I have an active portfolio of tax cases before the different zones of the tax appeal tribunal. So you will understand what I mean when I say that I consider this to be a privilege. What I intend to do today is to lead a discussion and not to teach. As a matter of fact, I don't consider myself competent to teach anybody in this room. So I shall be leading a discussion. And what I think will make this session interesting is if it is as interactive as possible. So we go straight to it. The first slide I have just gives us a quick look at the timelines for the Finance Act of 2020. It was certified by the Clerk of the National Assembly in December 2020. The President gave his assent to the law as passed on the 31st of December 2020, and the commencement date, the day that the Act came into force, is 1st January 2021. Now, I think that for proper context, it is important that we understand some of the factors that drove a lot of the changes that we see in the Finance Act. Before the enactment of the 2020 Finance Act, the National Assembly had enacted the Finance Act of 2019. Now, when you look at those two pieces of legislation, what you see is an attempt to resolve a lot of the disputations that have occurred as between taxpayers and the tax authorities over the years, leading to the passage of those acts. So, for example, if you look at the 2019 Finance Act, you see that one of the issues that that act dealt with was the controversy surrounding Section 19 of the Companies Income Tax Act, the so-called excess dividend tax. I know at least 6 different lawsuits at different times that went from the Tax Appeal Tribunal through the Federal High Court, even to the Court of Appeal on that issue. And that issue was essentially, what is the proper interpretation of that provision? So, for example, taxpayers complained that that provision should not apply to what we call franked investment income, which under the Companies Income Tax Act is declared to be exempt from further tax. If you look at the 2019 Finance Act, you see that there was an attempt, a very robust attempt, to resolve that controversy. Take another example, Section 10 of the VAT Act. I'm sure many of us here are familiar with the cases of Vodacom and FIRs, Gazprom. I had the privilege of arguing Vodacom before the Tax Appeal Tribunal in Abuja, where the Tax Appeal Tribunal agreed with my position. A few weeks after, the Tax Appeal Tribunal in Lagos rejected that position in the Vodacom case. Now, both the Gazprom case and the Vodacom case have gone on appeal to the Federal High Court and the Vodacom to the Court of Appeal. And the Court of Appeal has confirmed the position of the tax authority. Now, if you look at the Finance Act of 2020, you will also see that there was a clear attempt to resolve issues, the issues that gave rise to that controversy. You can say the same thing about what is the correct interpretation of public character for the purposes of the exemption granted under Section 23 of the Companies Income Tax Act. Again, I had the opportunity and the privilege to argue the case of the American International School against the FIRs at the Tax Appeal Tribunal in Lagos. In that particular case, the Federal Inland Revenue Service had taken the position that because the American International School is a very expensive school, and because it is expensive, not many Nigerians can afford to send their kids to that school. And as a result of that, the educational activities that the school engaged in were not of a public character. And it was for that reason that we went before the Tax Appeal Tribunal. And the Tax Appeal Tribunal in Lagos said, look, the test of public character is whether the business formation was registered as a limited liability company or as a company limited by guarantor and incorporated trustees, and whether surpluses are distributed to promoters of the entity. And in the wisdom of the Tax Appeal Tribunal in Lagos, they said that the American International School satisfied those criteria. Now today, the Finance Act of 2020 has now defined public character by reference to those two criteria. So again, you can see that there was a clear attempt by the legislature in the Finance Act to resolve that controversy. And I can go on and on and on. There's also the, of course, the issue with stamp duties on electronic transfers. I'm sure many of us are aware that at some point all the banks in Nigeria, filed an action against the government on that issue. Now, there has been a clear attempt as well to resolve that controversy. So what's my point? My point is that when you read through the Finance Act of 2020, you see that that act sets out to clarify ambiguous provisions of various tax statutes. It sets out to also, one other thing that, sometimes I don't forget this, one other thing that also drove the enactment of the act is the fact that Nigeria was losing a lot of revenue because a lot of our tax laws were so outmoded that they were not fitted for the sophistication we see in contemporary commercial arrangements. So take the taxation of companies that operate, for example. Up until the enactment of the Finance Act 2020, if you wanted to know whether a company, a non-resident company, was liable to tax in Nigeria, you had to go to Section 13(2). And those provisions relate only to physical presence, where a non-resident company is carrying on business in Nigeria and has some kind of physical presence. So the realization that commerce has moved far beyond physical activities in a particular jurisdiction was one of the things that drove the changes that we saw in the Finance Act of 2020. So please, can you flip to the next slide? So I just talked about, go back to that. I just talked about the key drivers, of the act. Then go to the next page. So again, almost reiterating the same point. Move on. So here I have listed all the tax statutes and some physical related statutes. The Finance Act of 2020 did not amend only tax statutes. It amended statutes like the Companies and Allied Matters Act, the Procurement Act, and the Fiscal Responsibility Act. So you see listed on that page all the statutes that were amended by the Finance Act. So what I'll try to do is, I understand that my time is limited, so I may not be able to go through all the specific changes. I'll just focus on the changes that I consider to be the more important changes. Section 11(2) of CETA exempts from tax interest on any loan granted by a bank to a company engaged in agricultural business, right? Now, what the Finance Act has done is actually to limit the types of activities that will benefit from that exemption. And the concept of primary agricultural production was introduced. So what that amendment does is that it takes out all intermediate activities, you know, in the agricultural value chain out of this exemption. So you have to be either engaged in primary crop production, primary husbandry production to be able to benefit from that exemption. Now, it's important that I talk about the amendment that was introduced by Section 7 of the Finance Act. It amended Section 13(2) of the Companies Income Tax Act. Now, for proper context, we need to go back to the 2019 Finance Act. Prior to the enactment of the 2019 Finance Act, like I said, a non-resident company that deriving income from Nigeria will only be liable to tax in Nigeria if that company fell one of four circumstances. The first was if that non-resident company had a fixed base of business in Nigeria. The second was if it did not have a fixed base of business, but was carrying out business through independent agents that had authority to conclude contracts on behalf of that non-resident company, there will be liability. The third situation was the so-called turnkey contract, where the non-resident is engaged in the contract of supplies, deliveries, construction, and installation, what we call the turnkey contract. And the last was when the tax authority has made adjustments as a related parties dealing with each other, not at arm's length. Now, any such adjusted income will be liable to tax. Those were the four circumstances. Now, these circumstances did not contemplate a non-resident company that is deriving benefits or income from Nigeria, but does not have any form of physical presence in Nigeria. So what the 2019 Finance Act did was to introduce two additional circumstances. The first is the one that targets companies that provide digital services in Nigeria. So going by this amendment, if a non-resident company is providing digital services to anyone who is resident in Nigeria, that non-resident company will be liable to pay tax in Nigeria on any income attributable to that activity, provided that that non-resident company has what is called a significant economic presence in Nigeria, SEP. So it would not matter that that company has not any presence in Nigeria. None of the employees of that company have set foot on Nigerian soil. All of that will be relevant. Once it is determined that that company has a significant economic presence in Nigeria, there will be tax liability. Now, the Act did not define what a SEP is. The authority to make that clarification was donated to the minister. The minister subsequently issued an order, the Significant Economic Presence Order. Now, what that order, I'm just summarizing that. If you're a company, a non-resident company playing in the digital space, if you earn income of 25 or more in any accounting period, then you'll be deemed to have significant economic presence. So what that means is that companies like Google, companies like Facebook, companies like, all the digital companies that provide services that are enjoyed in Nigeria will now come into the Nigerian tax by reason of this amendment. Now, the second circumstance that was introduced relates to non-resident companies that provide technical, professional, consultancy services in Nigeria. In the past, and I had had the occasion to argue during the course of litigation that on the law before these amendments were made, if someone who is not resident in Nigeria provides technical services or professional services to a Nigerian recipient wholly outside Nigeria, whatever income that person derives from providing those services will not be taxable. Now, that position has changed because once such a provider is deemed to have a significant economic presence in Nigeria, there will be tax liability. Although the law says that for a non-resident provider of the services, the withholding tax that's deducted will be the final tax. So that is with regard to section 12(3) of the Companies Income Tax Act. So these ones, these ones are not, they are pretty straightforward. So I'll try not to waste any time on them. Yes. So section 23 of the Companies Income Tax Act is the section that provides for profits and income that are exempt from tax. Again, before I get to the 2020 Finance Act, it's important for context to understand the changes that the 2019 Finance Act made to section 23. Now, the first change is that a new paragraph O was introduced. And what that paragraph does is to exempt the profits of small companies from tax. Now, it's important that I mention this. One of the innovations in the 20 Act is that Nigerian companies are now grouped into three: small companies, medium-sized companies, and large companies. Now, small companies are companies that have turnovers of 25 million naira or less. Medium-sized companies are companies that have 100 million to 25 million, and anything above that, you're a large company. Obviously, responding to the difficulties and challenges of doing business in Nigeria, tax concessions were granted to small and medium-sized companies. So if you're a small company, you're exempt from tax. If you're a medium-sized company, you only pay tax at 20%. And then if you're a large company, you pay at 30%. So that's one of the changes that the 2019 Finance Act made. The other one is just a clarification, So Nigerian companies that are engaged in export-oriented businesses, they enjoy a tax benefit when they make proceeds from their export activities. If they deploy those proceeds to purchase raw materials, equipment, and spare parts, the law says that they will not be required to pay tax on the portion of the proceeds that was so deployed. Now, what the Finance Act 2019 has done is to bring a bit more clarity on the point to say that for those companies, there will be pro rata application of tax on any portion that is not utilized to purchase either raw materials, equipment, or spare parts. Then there is the introduction of paragraph S, which exempts from tax the dividend and rental income received by a real estate investment company on behalf of its shareholders, provided that at least 75% of the income is distributed and the distribution is made within 12 months of the end of the financial year in which the dividend or rental income was earned. Now, the question is, what is the philosophy behind this? A real estate company earns income, rental income, dividend income. Now, before that income is earned, there must have been withholding tax applied to that income. So in the hands of the real estate company, that income is actually, in its true nature, franked investment income, because it is passive income that has been subjected to withholding tax. So it will not make sense to now apply another tax in the hands of the real estate company on that income. But the law says that the only way you can benefit from that exemption is that 25% of that income must be distributed to your shareholders, and the distribution must take place within 12 years from the end of that accounting period. 12 months, sorry. 12 months. Then there is the insertion of a new paragraph which exempts from tax compensating payments which qualify as dividends under Section 91C of the Act. Now, what are compensating payments? If you go back to the changes made to Section 9 of the Companies Income Tax Act by the Finance Act of 2019, you will see that the interest and dividend have been expanded to include what is described as compensating payments. Again, this is a very good example of changing the law to meet, the modern commercial realities of the country. So, for those of you who know a bit about capital market transactions, one of the things that one of the very popular transactions that we see in the capital markets now is what is called securities lending, right? Where you take, maybe you need securities for a number of commercial reasons, but you do not want to buy. What you do is you borrow. When you borrow, you may be to provide a collateral. It could be a cash-backed collateral for the securities that you're borrowing. It could be shares. Now, what the Finance Act 2019 has said is that if you borrow securities or shares from a lender or from an approved agent in an approved securities lending transaction, the SEC must approve it. If you borrow and you provide security, say cash, that cash will be in the custody of the lender. The person who lent you the securities will keep custody of the cash. Now, he's required to invest that cash one way or the other, maybe put it in an interest-bearing account. The interest that is paid to the lender, which the lender will transfer back to the borrower when the borrower returns the securities that have been borrowed, is interest. So the Finance Act 2019 defined interest to include that type of payment. And if I may just read from And I'm talking about Section 2. Section 2 of the Finance Act of 2019. Section 9 of the Companies Income Tax Act is amended in subsection 1, blah, blah, blah. Then it goes to say in subsection D, by inserting after paragraph C, a new paragraph D, for the purposes of this act, interest includes compensating payments received by a borrower from its approved agent or a lender in a regulated securities lending transaction, provided that the underlying transaction giving rise to the compensating payment is a receipt of interest by a lender on the collateral he received from its approved agent or borrower in a regulated securities exchange transaction. I don't know if with my explanation this is clear, or do I go through it again? Thank you. So in the same manner, the definition of a dividend has also been expanded. Again, I'll go through the transaction dynamics. So you have gone to borrow securities, say shares of Access Bank, from a borrower in a regulated securities lending transaction. During the time that you have custody of those shares that you have borrowed, GTB decides to pay a dividend. Now, that dividend does not belong to you because you are borrowing the securities. Title in the securities has not passed to you. So when you are returning the securities at the end of the transaction, you return the securities with the dividend. So the Finance Act has also defined. The problem is that in the past, the definitions of interest and dividend under our laws were not broad enough to cover these compensating payments. And what the Finance Act did simply was expand those definitions to make sure that they are captured. So I'll go back to remember I was discussing the changes made to Section 3, the exemption section, and I felt the need to explain what compensating payments meant. Now, inserting new paragraph T, which exempts from tax compensating payments which qualify as dividend under Section 91C of the Act received by a lender in a regulated securities lending transaction. Again, the question is, what is the rationale for this exemption? The rationale is simply that when the shares or the borrowed securities were in the hands of the borrower, for example, and dividends were paid, withholding tax must have been applied to those dividends. So when the borrower is returning them, it won't make sense to apply another tax to it, because in a manner of speaking, it represents franked investment income, passive income that has been subjected to withholding tax. So that's the rationale for the exemption. And how much time do I have? No, because I need to know how to space myself.
Don't worry.
Thank you. So, but it's important to note that holders of a rental, the shareholders of a real estate company, when they now receive dividends from the real estate company, those dividends are not exempt from tax. Because those dividends will no longer represent franked investment income in the hands of the shareholders. In the hands of the company, they will represent franked investment income, but it is not so in the hands of the shareholders. So there will not be any tax exemption. Yes. Okay, which is? No, no, it's in the hands of the company. It's in the hands of the company. Okay, so I'll skip some of the straightforward changes, because when you can actually understand very easily what those changes are about. Another change that was introduced by the Finance Act of 2020 is the clarification. Again, this is a very good example of the law saying that there's a problem and trying to resolve that problem. I also had the privilege of doing a matter before the Tax Appeal Tribunal, the Shell gas flare case. Now, what was the issue in that case? Prior to, I think, 2007, 2008, under the Associated Gas Reinjection Act, if a company, an oil and gas company, wanted to flare gas, there was a payment that that company was required to make to gain the right to flare gas, flare associated gas. That payment was made to the DPR. Now, initially, the DPR in the receipts that it issued described those payments as gas flare royalty payments. And there was no issue with deductibility. Oil companies were able to deduct such payments under Section 10 of the PPT Act in computing their PPT liability. 2008, the DPR started describing those payments as penalties for gas flaring. And immediately that happened, the Federal Inland Revenue Service said, hang on a minute. If these payments are penalty payments, they are not deductible. Because remember that the standard is wholly, exclusively, and necessarily. So a penalty is not an expense that necessarily incurred. It may be wholly, it may be exclusively, but definitely not necessarily incurred. So the FIRS said, no, we won't allow you to deduct these payments anymore. I can hear, I think Mrs. Uruguay was on the other side when we did that matter. That was before her elevation to the Tax Appeal Tribunal. She appeared for the FIRS in that matter at the Tax Appeal Tribunal in Lagos. Now, the argument that I made was simply that if you look at the Associated Gas Reinjection Act, there's a penalty for unlawful flaring of gas, and it is not payment of money. The penalty is forfeiture of your license. So I made the argument that these payments that were made to the DPR could be anything, but definitely not a penalty, because the statute itself has provided for the penalty for unlawful flaring of gas, which is that you forfeit your license. And the Tax Appeal Tribunal agreed with me and decided that case in favor of the Tax Appeal of Shell. Now, the FIRS would not have any of it. So there was an appeal to the Federal High Court, where my Lord Justice Liman overturned the decision of the Tax Appeal Tribunal. So as I speak to you this afternoon, that matter is pending at the Court of Appeal. Now, but what is important for the purposes of our discussion is that the Finance Act 2020 has now made an express provision which says that where a payment of a fine or a penalty is prescribed under a federal or state statute, then that payment cannot be deducted. I'm not sure that this provision directly answers the issue in the Shell case, but I mean, it's a good start. It's a good start. There cannot be any doubt now about whether the penalty prescribed in a statute can be deducted under Section 10 of the PPT Act, or indeed under any other section of the law. Sorry? Now, so the other one, I will also skip it, the one on gas optimization. It simply says that if you are a company playing in the downstream gas sector, if you have enjoyed a benefit under any statute, then you can take benefit of the tax benefit prescribed under Section 39. So that one is pretty forward. Now, the Finance Act 2020 also amended Section 53 of the Companies Income Tax Act. But what is interesting, again, this is another controversy that has raged over time. And I apologize again because the very first matter in which the TAT had an opportunity to determine this issue was also a matter that I did, the case of Weatherford, where the issue was, what is the appropriate timing for the application of interest and penalty under the Companies Income Tax Act? In Weatherford, the Tax Appeal Tribunal agreed that if a taxpayer has promptly objected to an assessment and promptly filed an appeal following the notice of refusal to amend issued by the tax authority, then you cannot, even if that matter was decided against the taxpayer, you cannot retroactively apply interest and penalty. Now, the Tax Appeal Tribunal has since moved on from that position. With the greatest respect, I do not agree that the law as it was allowed interest and penalty to be applied where there has been a prompt objection and a prompt appeal. Because essentially, if you look at the text of the law says that tax is due. I don't know why the National Assembly drafted those provisions the way they did, but the law says that tax is due when an assessment has become final and conclusive. And then the same law says that an assessment will not become final and conclusive if there has been a prompt objection and a prompt appeal. And those were the arguments that I made to the Tax Appeal Tribunal in Lagos, and they accepted the argument. Like I said, there have been other decisions of the Tax Appeal Tribunal that have departed from that position. But what is interesting is that the Finance Act 2020 also recognized that there was a problem with respect to this point. And it introduced an amendment to Section 58. Now, because of the importance of this amendment, I'm going to read it out. Every company filing a return under Section 52, 55, or 50 of this Act shall A, in the return, compute the tax payable by the company for the year of assessment, and B, forward with the tax return evidence of payment of the tax due, full stop, subsection 2, whereby a deliberate and dishonest act, the returns filed fail to declare the true and correct amount of profits or tax paid by the company is immediately liable to pay any outstanding tax so identified and assessed. Subsection 3. The outstanding tax shall be subject to penalty and interest. I said it. I said it. The outstanding tax shall be subject to penalty and interest in accordance with the provisions of this Act or any other relevant law. Now, listen to this. And the penalty and interest shall accrue from the date the incorrect return was filed. This was not the law before the Finance Act. This was not the law. So there was a clear recognition by the National Assembly that the law as it was did not adequately address the situation. And that's the reason for this amendment. But there's even an issue. There's an issue that has been raised by this amendment. And I'll just put it on the table. I'll just put it on the table for our consideration. If the language of the law says that whereby a deliberate and dishonest act, an incorrect self-assessment has been made, does it now mean that in cases where there has not been a deliberate and dishonest act, let's say, for example, that the law is not clear on a point and an objection has been made promptly and an appeal filed promptly, will interest still apply? Because the law is clear that there has to be a deliberate and dishonest act. I will not express my opinion. I'll put it on the I'll leave it on the table. But I thought that I should highlight it for our further consideration. I'm a bit confused, honestly, because I'm told that I have 15 minutes and I still have okay, let me go very quickly to capital gains tax, because I think I've spent sufficient time on CETA. Now, of course, the Finance Act 2020 made a number of amendments to the Capital Gains Tax Act. But the one that I want to focus on is, again, I keep making this remark, evidence of bringing the law to be in tune with modern realities. If you look at the old CGT Act, you see that compensation for loss of office, the exemption that was granted, the threshold was a very minimal amount. I can't remember whether it was 10,000 naira something. And why was that so? The CGT Act was an act that was enacted in the 60s, when 10,000 naira was a lot of money. So the Finance Act has now amended that provision to make the threshold to be 10 million naira. But the controversy, for me, the main controversy with that provision has not been addressed by the Finance Act. And what is that controversy? It is, what does compensation for loss of office mean? What does it mean? Is it when I resign from my employment, or when I'm sacked? The controversy between termination benefits and terminal benefits, that controversy has not been clarified. The Lagos State Internal Revenue Service some time ago issued, what's it called, like an advisory on this issue, to draw a distinction between a termination benefit and a terminal benefit. Now, a terminal benefit is, you have been with your company for 30 years you now decide that you want to retire, right? And you retire. And when you retire, the payment that is made to you is computed by reference to your conditions of employment. So the Lagos Internal Revenue Service says that payment is a terminal benefit and not a termination benefit. Not exactly. So that what will qualify as loss of office will be a termination benefit as opposed to terminal benefit. I agree with that position, but I think that for clarity, I mean, if I had an opportunity to advise the legislature, I would have recommended that that be made very clear in the law. I will leave the Capital Gains Tax Act and go to the Personal Income Tax Act. Of course, there are. So what I'm going to do is, apart from the slides, I actually did a proper paper. I did the one in that book actually is not the final thing. So I'm going to send the final paper to you so you can circulate it. So one of the things that the Finance Act did, one of the changes to the Personal Income Tax Act, is that the convoluted way of computing as accessible income, for commencement and for cessation of business has been simplified now by the Finance Act. So the Finance Act says that for commencement, your accessible income for the first year is your income from when you commence business to the end of your first accounting period. For the second year, it is from the day immediately following your the end of your accounting period to the next accounting period. So it's become very clear now under the amendments. So value-added tax, I'll end with this one. At the beginning, I talked about the controversy that was generated by Section 10 of the VAT Act. I have never seen a worse drafted piece of legislation like Section 10 of the VAT Act. Now, that section provided that where a non-resident company is carrying on business in Nigeria, that non-resident company will have to register for VAT using the address of its Nigerian counterpart, and that the non-resident company should include VAT in its invoice, and that the Nigerian recipient of the service should deduct the VAT and pay it to the tax authority, the so-called reverse charge, right? That provision generated a lot of controversy. At the last count, there were at least 15 lawsuits centered on that provision alone. Vodacom, that I already mentioned, Gazprom. Now, what the Finance Act has done, in my view, is to once and for all resolve this controversy. Because the Finance Act has done a number of things. The first thing that the Finance Act did, and I remember that I made this argument in the Gazprom matter. I made the argument that the destination, the so-called destination principle, was not part of law. What the incorporates the destination principle into the VAT Act. That it did by saying, introducing a new subsection 2 of Section 2 to the effect that for the purposes of this act, goods and services consumed or otherwise utilized in Nigeria are supplied in Nigeria. That's in a nutshell, that's the destination principle. Now, it goes ahead to say, a taxable supply shall be deemed to take place in Nigeria if A, in respect of goods, the goods are physically present in Nigeria at the time of supply, imported into Nigeria, assembled in Nigeria, or installed in Nigeria. Or the beneficial owner of the rights in or over the goods is a taxable person in Nigeria, and the goods or rights is situated, registered, or exercisable in Nigeria. Now, this is the important one. In respect of a service, the service is rendered in Nigeria by a person physically present in Nigeria at the time of providing the service, or the service is provided to and consumed by a person in Nigeria, regardless of whether the service is rendered within or outside Nigeria. So this has put paid to the controversy. It is wholly irrelevant where the provider of the service is. Once it is received in Nigeria, consumed in Nigeria, there is VAT on it. So I guess my time is up. So thank you very much. I really appreciate it.
There's no need to say to ask for another round of applause for National Advocate of Nigeria. The applause from the audience, I believe, is a testimonial to the fact that the presentation was fantastic. But in the African tradition, a couple of things that we may want to clarify, that we are not, maybe we do not agree with, maybe we have a different perspective. I don't know. The time is not really on our side, but at the same time, I think to make the presentation really interactive. I don't know if we have 1, 2. I have one here. I have another there, 2, and then 3, and 4. No more, 4, please. 4. Let me start from my right hand side. And then we have the paper presentation, the e-copy. The e-copy will be mailed to us today.
Thank you, Lennis Advocate. In view of the erudite presentation and taking into cognizance the OECD, the G20 or G21 meeting that will be coming up in Italy in July, and the projected agreement on minimum digital tax, and the pillars 1 and 2 of OECD recommendations on digital tax, which will likely projected to be agreed upon in October. When these changes occur and Nigeria wants to buy in, where will we, what will be our template now? Is it with respect to VAT, to amend the VAT Act, or to amend the SITA to correspond with this change, which is assured will take place this year. Thank you.
Thank you very much. No, please, let's take the question. Okay.
Thank you, sir. My name is Okunje Minusi. Thank you for the power presented. My comment is on this issue of royalty and gas player penalty and royalty of gas. There are two different things. Royalty of gas player is charged separately apart from penalty of gas player. And in the optional the Associated Gas and Irrigation Act you mentioned, what is mentioned about this is a fee to be paid. That is what it means when the changes are approved by the minister that you can clear gas. So it's a fee. And the section 11 of, section 10 of the PPT also allows such fee to be allowed, another reduction. So what we added there was that DPR was calling that fee as penalty. But another thing that it must be charged by the minister. Now the minister is trying to increase the fee sometimes ago, and the company refused to pay, and they kept paying the old rate. And the last judgment that was made in the court was said that nobody imposed the amount they are paying on them, therefore it cannot be an allowed reduction. That is what I need to say about that. Then the issue of RICO. RICO is reinvestment and real estate investment company. It's just a special purpose vehicle formed to invest in properties. So when the dividend is declared from those, when they are paying the rent, they will not pay the utility tax. They will not charge them utility tax. And so also when they are paying the dividend, they will not until when they are distributing. That's when that is just a pass through. Not just to avoid the same amount to be charged utility tax twice. That's the essence of that. Then second 39, I think I will deal with that when I'm talking when I'm speaking to the our task. Thank you.
Thank you very much. Mr. Obidemisi will take any paper later today. Yes.
Thank you very much. Mine is just an observation. Piecemeal amendments to our tax law. Carry new one into the old scheme. I think it is time for us. We have come a long way. The Companies One Tax Act, for instance, was last revised in 1979. Some provisions were expected to 477, the sister 61. And now most countries are talking about tax laws in plain English language. One of my last assignments was on the draft of tax laws. Unfortunately, the Minister of Finance invited IMF technical assistance program, and that work was commenced. Some of my colleagues who are still there, Mr. Bunyan, they are out there, got a long way. What was left is for governments to take definite decisions. There's a draft for government income tax. Imagine the charging provisions of CPAC with charging provisions of PTAC. Having a tax administration law, amalgamation of all the various districts, the VAT law. So these are issues. The government take it on. About 2 years ago, I also discussed it. I raised the issue of miscellaneous decrees to update our tax laws. You talk about raising money. No, spending money without talking about raising money through taxation. Let this go, if my colleagues agree, as a key resolution of this retreat. Let the government go back and take on an engagement they started during the time of Dr. Mansour Mokhtar, Minister of Finance, to rewrite our tax laws so that we will simplify and update the tax laws. Thank you very much.
Thank you very, very much, sir. And the last intervention. No, you didn't raise it. Wow. Sorry, overruled.
Sorry. I just want to refer to both cases of Gazprom and Vodacom, and I want to ask you the subject of the supply, as we heard today, and in view of the amendment, Is it actually a service or a good? What was being supplied in both cases? Was it a good? Was it a supply? Was it a service? Thank you. And then finally,
Thank you very much. Mine is an observation, and it's a policy issue. And I think the relevant representatives of various offices in this class should take note of. Globally, the direction now is increasing simplification of tax laws. Now, with the various finance acts that we now have in Nigeria, the implication for tax advisors is that if I have value-added tax act on my table, and we have finance act by the side, I'm reading CETA, and we have finance act 2020 by my side. It is high time we followed the global practice of setting a timeline to harmonize these amendments. Look, investors are concerned. Some of us advise on multinational transactions, and we can tell that when we send legal opinion to our colleagues overseas, they begin to look and say, oh, you mean your value-added tax is not amended by Value-Added Tax Amendment Act? That that's one. So my position is that, and I'm happy we have policymakers here. We should begin to put those amendments in their respective principal legislations after some time, so that those finance acts can begin to disappear from the bodies of our law. It makes things much simpler. Thank you very much.
Thank you very much. The first question from our guy, Chief Eze. So, do I have the attention, sir? Okay. So there's actually a very simple answer to your question, which is that, you know, the set order that was issued by the minister, the significant economic presence order that was issued. If you look at, I think it's section 1 sub 3. It says that notwithstanding the provisions of sub paragraph 1 of this paragraph, any company other than a Nigerian company covered under a multilateral agreement or consensus arrangement to address the tax challenges arising from the digitalization of the economy, to which Nigeria is a part, shall be treated in accordance with that agreement or arrangement. So I think this answers the question. When those protocols come in, any taxpayer that's governed by the protocol will be treated in accordance with the terms of the protocol. But what I think is a more controversial issue is, what is the interaction between the amendments made to section 13.2 and the various tax treaties that Nigeria have executed? Because conventional wisdom is that if you are resident in the country, then you're not necessarily governed by the provisions of municipal tax laws. So if you look at the treaties, I haven't seen any one of them that contains any provisions on the taxation of digital companies. So I could say that there's a lacuna in the treaties. What's the position? Is the argument that because the treaties are silent, that even non-resident companies that play in the digital space that are resident in treaty countries will also come under the under these amendments? You know, I have my personal view. I don't think that that is what it should be. But I think that that is even a more controversial point. But on this one, it's clear that if, as a non-resident company, you play or you're resident in a country that has a multilateral arrangement or agreement, you govern under those arrangements. So I completely agree with you. What I said during my presentation was that the DPR used to describe, clearly there's a difference between that fee and the royalty that you pay, whether under the PPT Act or the Offshore Act. But the DPR at some point was describing the fees, yes, as penalties. And that was what caught the attention of the FIRS. The FIRS said, if these are penalties, then they cannot be deductible. And that was what started the controversy. And sir, the point you made, I think, is similar to the point that my friend over there made. You know, simplicity is fashionable when it comes to tax laws. You should be able to have one document that tells you everything you need to know about a particular tax. A situation where, you know, there was an arbitration that my friend was involved in a few years ago, you know, and we discovered that even in the process of compiling the laws of the Federation, some amendments were not reflected. So it was possible for you to take the law, you know, and look at it and then advise a client and then find out that you were wrong because you have missed some amendment that is not even part of the laws of the Federation. So it makes sense that all these amendments are contained in one document so that you can look at it and get a holistic picture of what the position of the law is. Then the final question. I don't want to give you wrong information. I'm not quite sure now what Vodacom was about, but the Gascon that I did was clearly a service. It was a service that was rendered by the non-resident company to a Nigerian company. I'm not sure what was the issue in Vodacom, and I don't want to give you wrong information. So thank you very much.
The coordinating secretary, Ms. Bola, to formally present our token of award to Mr. Chukwuka.
Secretariats, chairmen, commissioners of the tax appeal tribunals, we thank you for this wonderful presentation. Please.
Thank you very much. Thank you very much, Mr. Chukwuka, Advocate of Nigeria. One particular court that has been mentioned and that has featured prominently since we started this program this morning is the Federal High Court. Almost everyone who has spoken has had something to say about the Federal High Court. And after regard to the way the Tax Appeal Tribunal is constituted, the Tax Appeal Tribunal, the TAT, is not an end, it's a means to an end. The decisions of Tax Appeal Tribunal does not end at the Tax Appeal Tribunal. It goes upstairs. And the first stage on that judicial ladder is the Federal High Court. That's why we believe it's very important for us to have a judge of the Federal High Court to come to this retreat to share experience with us about what they have observed about our decisions at the Tax Appeal Tribunal. And to do justice to this topic, and the topic is after tax appeal, what next? After tax appeal, what next? Issues and perspective of the Federal High Court. It's very important for us to hear from the other side about what we are doing. And to do justice to that is no other person than my Lord, Honorable Justice Taiwo. His Lordship attended the University of Ife when it was University of Ife, the Great Ife, not Obafemi University, where His Lordship obtained Bachelor's of Arts in History and Political Science in 1998. His Lordship served in the compulsory national NYSC program at NDA Kaduna as an instructor in international affairs from 1980 to 1981. He went back to University of Ibadan, the Premier University, where where His Lordship backed his law degree in 1985 and was called to Nigerian Bar as solicitor and barrister in 1986. Justice Taiwo worked in the law firms of Okunsanya and the law firm of Professor Steve Olawoye before His Lordship established his own law firm, Taiwo and Co. in 1991. He was in active legal practice as a lawyer, and he was involved in many cases at all levels of the court until in 2015, when he was appointed as sworn in as a judge of the Federal High Court. When His Lordship was in Ibadan, he was the president of the Law Student Society. He was also very active in Nigerian Bar Association when he was in practice. He was at one time the chairman NBA Lagos branch, secretary NBA Lagos branch, second vice chairman NBA Lagos branch, and later the national second vice president of NBA. His Lordship was a member of the NEC of NBA for many years and was appointed member, Law Reform and Welfare Committee and the Human Rights Institute of Nigerian Bar Association. His Lordship represented the NBA at the 600th years anniversary of the signing of the Magna Carta, the Bill of Rights, in 2014 in London, United Kingdom. He was the NBA representative on the governing board of the NOA, National Orientation Agency, from 2013 until he was appointed a judge. He's currently a member of the Nigerian Judicial Expert Group on Law and Religious Studies for the International Center for Law and Religion. His Lordship is a member of the International Bar Association and has attended many seminars and conferences at home and abroad, and has described papers delivered at some of these seminars and conferences. His Lordship is married to my Lord, Honorable Justice Oluwatoyin Abosede of the High Court of Lagos State since 1981. Happy 40th anniversary, sir. Thank you, sir. They are blessed with children, two of whom are also lawyers, so we have created the dynasty of lawyers, and who are also in practice. His Lordship is a grandfather who loves traveling, reading, watching documentary, music, and walking. Distinguished ladies and gentlemen, I have the pleasure of bringing to the podium His Lordship, Honorable Justice Taiwo O. Taiwo. Thank you. His Lordship paper is at page 85
Yes,
of your
85 to 91, actually, precisely.
Thank you.
Good afternoon, members of my table, distinguished ladies and gentlemen. It is also an honor and privilege to be before this distinguished audience, and it is not a class, because we are not meant to teach anybody. And what happens is when a case comes before the court, what the judge does is, after consideration of the two sides, he reads his judgments. From then, anything can happen. So I thank the organizers, and I'm humbled to be part of this important discussion and to share my thoughts on the topic of today. This paper is my conception of the topic at hand. As we all know, that courts of coordinate jurisdiction are not made to adhere to the decision of one another, except where the law is firmly established and stated in the law and by the superior courts. There's no doubt that the issue of taxation is very important and more often than not, a very thorny and sensitive issue of taxation. Between the taxpayers and tax authorities at the federal and state levels. I deliberately kept out my decisions on this issue because my court, like all high courts, federal high courts, is not the final destination from the decisions of noble men and women before this afternoon. So all the cases I brought, which can be seen as stated by Mr. Akinshola at pages 85 to 91 of the bundle of documents, are not my cases, because I know some of them are on appeal, and I do not have to express any opinion. I'm a functious official until the decision is made final at the Supreme Court. Then it can be said that yes, that was Taiwo's decision. If I'm overruled, so be it. Because like I said today, I would like decisions to be tested up to the Supreme Court. After the Supreme Court, we go to God. I know that most people will not want to go to God Almighty because it's not yet the appointed time. Oh, okay, my face mask. Sorry. This corona has made our dressing permanent. If I don't even feel as if I'm talking to you without a mask, it's part of me now. When I'm leaving the house, I feel like I'm naked without a face mask. Anyway, I'm sure that very soon God will make all these things shall pass through. The National Tax Policy and Administration System is susceptible to disputes between taxpayers and tax administrators. The reason is not far-fetched. While some may think it is just adequate, some may think it is too much, and others may think it was too. So it depends on the way each individual looks at it. There are many reasons why people resent, if I may use the word, whatever they are asked to pay as tax. There must therefore be an application system in place to resolve objections to what the tax authorities fix as tax payable by the individual or a business concern. And this will lead me, because I'm going to be very brief, I'm not going to read through the papers, I'll just take some portions of it. And this paper will examine the tax appeal procedure under the current legal regime in Nigeria and attempt to provide answers to jurisdictional conflicts arising from the decision of the courts of law on the constitutionality of the Tax Appeal Tribunal and the exclusive jurisdiction of the Federal High Court under Section 251 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Yes, I now went to state that the Tax Appeal Tribunal replaced the body of appeal commissioners. I'm sure everybody knows that. So I'm going to skip all that and also skip all the legislations that the tribunal is meant to decide. And that's from Company Income Tax Act 1, 2, 3, 4, 5, 6, and 7. So in the meantime, the foregoing acts, including the Federal Inland Revenue Service Establishment Act 2007 and other finance revenue related acts of the National Assembly, have been substantially amended or altered by the new Finance Act 2020. I'm sure justice has been done to that. We are not to do anything, we are to interpret, and until situations are brought before us, we are not to say anything.
Even if I have my opinion about anything, I'm not meant to express it publicly. I may have my observations as well, because we are all human beings, and because of our training, we are meant to just deal with those things that are brought before us and express otherwise. Some people may say, oh, at a particular forum, you express your opinion, and by virtue of that, you are biased. I don't want to fall into that error. So I'm just going to limit myself to the procedural system, where from the tax appeal tribunal to the Federal High Court, from then to the Court of Appeal, the procedure in the Court of Appeal, I'm not going to go into that. Then from the Court of Appeal to the Supreme Court. So I'm not going to deal on the zones of TAT. We all know where these zones are. So in the exercise of the powers conferred by paragraph 21 of the fifth schedule to the FRS Establishment Act 2007 and such other enabling powers, the then Minister of Finance issued the Tax Appeal Tribunal Procedure Rules 2010. Meanwhile, paragraph 21, sub 1 and 3 of the fifth schedule to the Act equally empowers the Tax Appeal Tribunal TAT to make rules regulating its procedures, and I quote, any proceeding before it shall be deemed to be a judicial proceedings, end of quote, and the Tax Appeal Tribunal, I open another quote, shall be deemed to be a civil court for all purposes. And you know how lawyers are. Mr. Ekwuazo was able to point out some areas. We can all agree when he stated that he had to fight some battles before the tribunal. So, however, by this provision, the Tax Appeal Tribunal could be assumed to either be within the ambit of section 6, sub 4, sub A of the Constitution of the Federal Republic of Nigeria, 1999, as amended, as a body with subordinate position to a high court, invariably the Federal High Court in the circumstance, or an administrative body that ought to be approached first of national tax disputes as a precondition to invoking the decision of the Federal High Court under section 251, sub 1, sub B of the current Nigerian Constitution. We have dealt with the issues of whether it is whether it's quasi-judicial, but for me, I think if it must be told, if people are to apply the law, they should be as a judicial body, not really administrative per se, because if you have to do, I'm sure when people appear before the TAT, they cite cases, and the gentlemen and the commissioners go back and they decide on these cases, whether they're right or they're wrong. They take it from the Federal High Court. If the Federal High Court position has been overruled, they go to the Court of Appeal. If the Court of Appeal position has been overruled, they go to the Supreme Court. And so this is a matter for which I think if we are to specialize some aspects of our judicial procedure, I think the TAT should be a specialized court. That is my opinion. I'm sure nobody will bring some before me because I'm not going to deal with that issue. Now, we have also stated in my paper the cases on the issue of what the TAT is. I've cited my Lord Justice Bubra. I cited my Lord Gure as it then was. And then I moved on to the case of Ocean and Oil Limited against FBIR, where my Lord CJ before IN Alta held that the Federal High Court lacked decision to entertain the appellant's suit on the ground that the appellant failed to first appeal to the body of appeal commissioner, now replaced with the TAT, before the suit was filed at the court. However, the Court of Appeal dismissed the appeal for initiating the suit at the lower court with invalid or incompetent originating processes. So it means the first port of call is the TAT. But then there are some issues on that point. Like I said, I'm not going to go into that, as I have dealt with something like that before, that they did not go before the TAT before approaching the Federal High Court. So that has to do with VAT anyway, and payment of tax by companies that are not based in Nigeria. The Court of Appeal overruled the decision of AFA Ademola J FRS against TSKJ, Constructor International Sociedade in Tribunal. It's not my language. So, and I'm sure there are so many people that are more learned in this, that are bilingual, so to say. So, Paraboki GSA delivering the leading judgment when it's held in time there, that the cumulative effect of this provision is that the tax appeal tribunal is a mere administrative tax appeal tribunal, which is not an unconcurrent decision of the Federal High Court, nor can it in any way be capable of usurping the decision of the Federal High Court. It serves as an administrative procedure or condition precedent to its actions, tax-related actions before the Federal High Court. The decision of the TAT is not a usurpation of the decision of the Federal High Court. The tax appeal tribunal is a condition precedent to the jurisdiction of the Federal High Court to entertain the subject matter of this appeal. End of quote. Also, the Court of Appeal, in the case of CNOOC, Exploration and Production Nigeria Limited, and another, against NNPC and another, also stated that the combined effect of its earlier decision in Shell, Nigeria Exploration and Production and others, against FRS and others, and another, unreported, appeal number CA/A/208/2012, delivered on 31st August 2016, page 38, and Exploration Production Nigeria Limited, and another against Nigeria NNPC, unreported appeal number CA/A/507/2012, delivered on 22nd July 2020, pages 11 to 12, is that the tax appeal tribunal has jurisdiction to entertain tax matters. The court approved of the procedure of first appealing to the TAT before approaching the Federal High Court in matters of such nature. Thereafter, the Court of Appeal and then the Supreme. In essence, the creation of the TAT is not in conflict with the exclusive jurisdiction of the Federal High Court. Now we go on to the position of the law for resolution of tax dispute arising from national taxation and revenue has therefore been settled by the criteria of decided cases referred to above. By virtue of paragraph 17 of 5 of the fifth schedule to the FRS Establishment Act 2007, the learned chief judge of the Federal High Court is vested with powers to make rules of procedure in respect of appeals under the Act, and until such rules are made, the Federal High Court civil procedure rules shall apply. In furtherance of the enabling law and powers, the Federal High Court's Tax Appeals Rules 1992 was enacted to replace the Tax Appeal Rules of 1984. In a similar vein, Order 24 of the Tax Appeal Tribunal Procedure Rules 2010 also governs appeals from the decision of the tribunal. The position of those aforestated rules on tax appeals are contemporaneous and complementary in pursuing appeals from the tribunal to the Federal High Court. I don't want to belabor the issue. The tax appeal tribunal is very clear and unambiguous, and it is tried law that you give effect to ordinary meaning in any legislation, especially where there are no ambiguities. So we move on to paragraph 17(2) of the fifth schedule to the FRS Establishment Act provides that the notice of appeals filed pursuant to paragraph 1 shall set out all the grounds of appeal on which the cases predicated. We also have similar in order 1, rule 3 of the Federal High Court rules, where the notice of appeal shall state whether the whole or part only of the decision of TAT is being complained of. In case of the letter shall specify such part. In addition, the notice of appeal shall state the exact nature of the relief sought, the names and addresses of all parties directly affected by the appeal, and shall carry endorsement of address for service on the respective parties. Then, order 105 of the FHC tax rules allows any notice, including a notice of appeal or other court processes, to be signed by either an appellant or a respondent, as the case may be, legal practitioner representing the parties, and any person who has been donated a special power of attorney by the appellant or respondent. I think this is only a civil matter. In criminal matters, which is beyond the purview of the TAT, is only the defendant, that is the person convicted, that can sign his notice of appeal. Order 9 of the FHC tax rules governs service of processes, and we all know the importance of service. And then the fact that the Federal High Court is one. So decided in the case of Akere against Abraham, the Supreme Court held entirely the High Court by virtue of Section 19 of the Federal High Court Act and Order 6/31 of the Federal High Court Procedure Rules 2009. The Federal, we now have a new 2019. The Federal High Court has jurisdiction throughout the Federation, and service out of jurisdiction is defined as out of the Federal Republic of Nigeria, or in Ondo State is within Nigeria, and therefore within the jurisdiction of the Federal High Court sitting in Abuja. End of quote. So service can be effected without asking for the permission of the court to effect service out of jurisdiction. And then the notice of appeal is the foundation upon which other processes rest in the appeal. Thus, the notice of appeal is the originating process that gives birth to the proceedings at the appellate court, in this case, the Federal High Court. As such, any failure to serve an originating process on the part to the proceedings is fatal. To proceed without evidence of service of the notice and grounds of appeal will amount to nullity. So that is stated in Adebola against Osi, where the Supreme Court held entirely as follows. I quote, "This court has steadily held that the service of an initiating process, which the notice of appeal is sine qua non for a court to assume jurisdiction over a case." And I think this one also applies to any process that comes before the TAT. It must be served on the other party. Otherwise, that's procedure, no matter how well conducted, will be a nullity application, and it's likely to be set aside. Any inconsistency in the provisions of the FRS Establishment Act 2007 and the Tax Appeal Tribunal Procedure Rules, where powers and decision conferred on the Federal High Court under Section 251 of the Constitution and Section 28 of the Federal High Court Act shall be in abeyance. That is, the Federal High Court, powers of the Federal High Court, Section 251 and Section 251 of the Constitution and 28 of the Federal High Court Act. The state of consistency will be nullity. Therefore, the restriction of appeal that could lie from the decision of the TAT to the Federal High Court on points of law only, though was well intended for speedy resolution of tax appeal, limits access to justice. The appellate decision of the Federal High Court should not be whittled down or limited to points of law only. Rather, the operative was used in Section 28, Sub 1, Sub A of the Federal High Court Act and Order 302 of the Federal High Court Tax Appeals, which interchangeably are as follows. The decision in quote, decisions, end of quote, the TAT or quote, all appeals from the TAT depending on the circumstance of this case, allow all appeals. Thus, by implication, appeals on issues of facts or possibly issues of facts and mixed law will as well lie from the TAT to the Federal High Court for adjudication. I'm going to skip the other one that from Order 202 of the Federal High Court Tax Appeal Rules, which has to do with what the Registrar of Courts should do. The Registrar of Court and, of course, the Secretary of the Tribunal. So I'll go to, it shall be the duty of the Secretary to the TAT to cause copies of proceedings required for an appeal to be prepared with utmost dispatch. And upon receipt of a notice of appeal, it shall compile the record of proceedings and all exhibits tendered before the TAT. This shall be duly authenticated or certified together with a copy of the notice of appeal filed, and then have them verified by affidavit. Thereafter, it shall be submitted, it shall be transmitted to the Chief Registrar of the Federal. Hence, it is only after this that the appeal is deemed to have been entered at the appellate court. And in the circumstance, the Federal High Court appeal could only be properly brought by a notice of appeal filed in the register of the Federal High Court, and afterwards notify the tribunal through the Secretary, who is required to transmit the record of proceedings to the Federal High Court. I want to state that there are, if you notice, I highlighted some of these orders and I put them as footnotes, so you can easily refer to them from the bundle, from the papers presented. Somebody 15 minutes more. You put it, that was for the others. I'm sure I'm not going to spend up to 15 minutes. So, it says an appeal shall be determined by way of hearing if the appellant so elects, and where permitted by the enabling law otherwise. The appeal shall be determined upon the record of proceedings transmitted from the TAT. The latter part of the position of Order 3, Rule 3, affirms the position of the court of law that the TAT is merely an administrative tax body and not a court of law, so properly so called. Hence, appeals is to be conducted based on the record of proceedings transmitted from the tribunal, since there are no suits instituted before the TAT, and the tribunal, in the real sense of it, is not within the codification of our court system. Generally, an appeal is in the nature of a rehearing in respect of all the issues raised in the case, and it is considered a continuation of the original suit rather than a new action as decided in the recent decision of the Supreme Court in Access Bank PLC against Mr. ANC Onwulu. That is, the citation is there. It's a recent 2021 decision. The courts may allow an amendment to a defective ground of appeal upon considering the interest of the respondent as to service and costs. Any ground of appeal which is vague or disposes no cost may be struck out by the court. Where an appeal is being prosecuted on the basis of a hearing in accordance with FAC rules, within 15 days after the conclusion of evidence, the appellant shall file a written address of counsel in support of his case. An appeal which is being determined by way of hearing shall be conducted on the basis of records of appeal prepared by the appellant within 15 days after the date of service on him of the record of proceedings by the Secretary of the TAT. Supplementary records can also be prepared, and then filing of the records is meant to be within 30 days and filed on the respondent, and then the respondent will have also the same number of days to file his brief of argument, and of course, the brief is within 14 days. Order 506 of the Federal High Court tax rules governs argument of appeals, including a cross appeal, which shall be argued together with the main appeal. If an appellant fails to file his brief within the time stipulated or within the time extended by the court, the respondent may apply to the court for the appeal to be dismissed for want of prosecution. A dismissal for failure to file brief shall amount to a dismissal on the merits. That has been the position of the law, and the Supreme Court has also stated that in the case of Ali Alaba International Limited and another against Sterling Bank. And I dare say that no matter how well attended the legal practitioner is, once your appeal is dismissed, it is stated to be dismissed on the merits. Like I said, you can only appeal to God after the Supreme Court. An appellant may also abandon his appeal by giving a written notice of abandonment. Some people think that it is not right. You may have a good case, no doubt, but once your case is dismissed for one reason or the other, that's it. Nobody can do this. I think there was a time when I was in practice, I saw there was one case, the appeal was dismissed at the Court of Appeal. They went on to the Supreme Court, and the Supreme Court affirmed the decision of the Court of Appeal that the appeal was dismissed on merits. Then the Supreme Court now said that until the rules are changed, there's nothing they could do. And I think at that time, as a member, active member of the NB, I wrote a letter to the then President of the Court of Appeal that they need to change the rules regarding this, in line with the decision of the Supreme Court or advice of the Supreme Court. But looking at it again, if you are lethargic in your attitude to your work or to your job, and your matter is dismissed for want of diligence, I don't think you deserve any sympathy. That is the way I look at it. And I think the law should be left like that. Otherwise, you have a lot of frivolous multiplicity of actions to the Court of Appeal and the Supreme Court. I think that thing should be changed. The decision of the Federal High Court on appeals from any decision of the Tax Appeal Tribunal is still subject to appeal to the Court of Appeal and of course to the Supreme Court. This is the constitutional right of any person, corporate or incorporate, dissatisfied with the decision of the Federal High Court or the Court of Appeal to take his case further to the Supreme Court. This is therefore the final destination, and the decision of the Supreme Court is binding on all parties in the case and all the courts below. In fact, you must. There are cases where even the federal government, after the Supreme Court, they must follow the decision of the Supreme Court. And in fact, there's a section in the Constitution of the Federal Republic of Nigeria that all parties are to obey and execute any decision of the Supreme Court. Therefore, the final destination and the decision of of Supreme Court is binding on all parties in the case and all the costs below. Therefore, after appeal to the Federal High Court from the decision of the Tax Appeal Tribunal, the drums do not stop, neither does dancing end. Parties continue to beat the drums and dance until the music ends and the Supreme Court. Thank you.
We thank His Lordship for that very beautiful presentation. Please, can we give him a round? So now it's time for lunch. So no questions, so it's time for lunch. So the lunch will be at Orient Restaurant. So when you go out, just turn right. And for those fasting, there are arrangements for you, so you may not need to go to the restaurant. If you are fasting, you can remain in the hall or just walk around. Or if you are interested in the lunch, you can go to the Orient Restaurant. If you go out, then turn right. Thank you very much. Lunch is 30 minutes, but before we leave, please, the award for His Lordship.
We want to show our token of appreciation to His Lordship for the beautiful presentation. Thank you. Thank you very much. So lunch is served, please. We have only 30 minutes for lunch, please. Our next speaker is around, and the topic is going to be engaging, and the presenter is wonderful, I can assure you. You will really enjoy it. Thank you very much.
as it tackles on the paper titled Alternative Dispute Resolution in Tax Disputes. Thank you very much.
Thank you very much, and good afternoon. Primarily, just to thank the Tax Appeal Tribunal for inviting me to address this retreat. It's a subject that is particularly close to my heart, and it's a discussion that I hope will be very engaging, particularly because I'm mindful of the effects lunch has on one's concentration. So in that regard, I'm hoping ADR would be my response to attention deficit or attention deficit response. So how are we going to have this discussion? What I was keen to achieve was to have a discussion that is as useful for the TAT as possible. So what I didn't want to do was to dwell too much on to say, okay, these are the different ADR parts. This is what you do in each one. What I hope to do is to show insights from decisions of the TAT to say, okay, where are the areas of inefficiency and how do I think ADR can enhance your efficiency as a body? So that is where I hope the discussion will go. So the first half of the presentation, I will not dwell too much on, subject to what the response is. What I hope to do is focus more on the second part that looks at data, and that data comes from decisions from the Tax Appeal Tribunal. So why are we having this discussion in the first place? Could you please assist me by skipping forward one slide? Why are we having this discussion? What is the problem? Because the fact that disputes exist, that's not the problem in and of itself. Because in any system where there's respect for the rule of law, then there should be an avenue to challenge decisions that we're not comfortable with or that we believe are wrong. So having tax disputes is not the problem. The problem arises, and I apologize if the text is small, but I know it's the presentation is in your booklets. The problem is in certain jurisdictions where the tax litigation becomes so excessive that it diminishes efficiency. And that arises from one of three problems. If you skip forward again, just one click. So it can arise from one of three things. There's a high volume of litigation challenging tax assessments. The second issue is concerned with the system. There's a delay in resolving those disputes. One, please. And the third element could be a lack of judicial capacity. So it can have in jurisdictions either not enough judges or not enough judges with expertise. And either one or a combination of all these three can lead to excessive tax litigation. And that's a problem for two reasons. For the state, it delays the collection of tax revenue. So there's a direct impact on the revenue of the government of the federation. For the parties, it diminishes confidence in the tax system because it's perceived as being uncertain and inefficient. And in the establishment of the Tax Appeal Tribunal, I think the federal government was alive to this. So I've taken this slide from directly, and I updated it so it might not be in your brochure, but I took this directly from the TAT website. And part of the tribunal's executive brief is to minimize the delays and bottlenecks in the adjudication of tax matters from the traditional court system, improve taxpayers' confidence in our tax system, and I'm skipping forward a bit, promote early and speedy determination of matters without compromising the principle of equity and fairness. Okay, so the TAT was established in and of itself as an alternative to the traditional court system because there was a recognition that that court system was inefficient. It did not minimize delays or bottlenecks, neither did it promote the early and speedy determination of matters. So can we skip forward one slide, please? So now we come to the discussion as to ADR and tax disputes, because I've set the scene as to what the normal path is. Historically, these have been resolved either by litigation or by negotiation. So ADR in the sense of tax disputes represents an alternative means, right? So ADR in this sense will involve negotiation, but it could also involve mediation, which I'll come to, and more controversially in this jurisdiction, arbitration. There's a question as to whether tax disputes are arbitrable under Nigerian law. And it's a discussion I will touch more on towards the end of this, so we don't lose sight of time. But ADR's purpose in the sense of tax disputes is to help the parties resolve the disputes in a cost-efficient manner and to agree, help them agree on issues in which they reach a stalemate. So under ADR, the parties to the tax disputes will involve a third party to facilitate an agreement between them. That's the context I'm looking at it here. So not necessarily the arbitration context, which is also adversarial, as with the TAT. I'm looking more of a facilitative process where the parties either by themselves reach an agreement from areas that they couldn't quite reach consensus, or where there's a stalemate between them, a neutral third party comes in and facilitates discussions between both of them in order to reach consensus. Can we go forward? So that is the essence of a mediation process. Okay, so when is it suitable? Because if this process is going to be useful for the tax commissioners, you need to be able to identify factual matrix where the dispute, you can make an informed decision to say this particular dispute is suited to mediation. And I've listed about 6 examples here. All of the common denominator between all of them is that the parties are capable of compromising any of these. It is not set down by law. So you can't, for instance, contract out of legal provisions. But you can reach a consensus where there's a dispute to the facts, or where the communications are broken down between the parties. So if you're noticing that from the dispute before you, then there is more of a reason to say, okay, let's try an ADR track for this particular dispute. If we can go forward, please. Also important is to identify what type of disputes are not suitable. Because the last thing you want is to refer the parties to an ADR track, and they come back to say, unfortunately, we were unable to settle. It's a waste of time, it's a waste of money. And it is contrary to the purpose for which the TAT was established. So again, I've listed some examples here. Cases that turn entirely on law, unsuitable, where they might not turn entirely on law, but there might be a principle that TAT wants a precedent on, so it affects other decisions, it's binding on other decisions. So again, that might inform you to remove the case from an ADR track. Or where the case, in certain cases, where the TAT suspects that something fishy is going on. And there was actually a decision I saw that the reduction, so there was an initial tax assessment. The reduction was so large, the TAT questioned its legitimacy. So there might be reasons to suspect that something is not quite right here. Again, that shouldn't go to mediation. Okay, so what are the advantages? We all know this. Unless you want me to, I'm not going to dwell too much on this slide. What are the advantages? Speed is the obvious one. It takes a much shorter time to reach a negotiated settlement than it is to let me not say litigate, to resolve the dispute through the TAT, have a possible appeal to the Federal High Court, and then it goes through the 2 channels of appeal, Court of Appeal, Supreme Court. So if the parties negotiate a settlement, then they're much more likely to own it. So that's one advantage. Confidentiality is another one. Naturally, any dispute before an adjudicative body that is established by law is open to public. So one of the reasons for a breakdown in communication, let's say the tax authority is very aggressive to say, okay, well, if you do not settle your outstanding indebtedness, we will blow this up and we will file proceedings. It's going to be in public, or we'll air your dirty laundry in public. So it might be a tactic to say, okay, well, let's discuss and maintain confidentiality between us. If we can skip forward, please. And naturally, advantages as to costs, not necessarily costs of filing fees. What I mean is the costs of retaining counsel, the costs to the business if there is a pause in activity, etc. And also control. The parties have control over an ADR process in comparison with proceedings before the TAT. The best example I can think of is you can appoint your mediator or your arbitrator, but of course you cannot determine which commissioner will determine your dispute. So let's go forward. So those were the advantages. Now the disadvantages. I've mentioned one. If the parties are unable to settle, then they have to come back to the TAT. And any resources in terms of time and cost they've expended in that ADR process, you can't get it back. So it's important to know what disputes are suitable to be referred to an ADR track before taking that decision. If we can go forward, please. There's not a fact-finding mechanism. So, for instance, where the dispute is highly fact-based. So I bring one set of facts to say this is applicable. The tax authority says, actually, no, it's this set of facts. You might want a situation where there's an evaluative mechanism to weigh both sides, the facts on both sides, to determine which side is correct. Now, for this, referring to more to negotiation. In arbitration, naturally, yes, there is a fact-finding mechanism, but I'm not referring to arbitration for this example. If we can go forward, please. Okay, now comes to the interesting part for me. So in the course of preparing this presentation, we took a look at the decisions published on the TAT's website, and I must commend the Tribunal for making its decisions public. So we took a look at 73 decisions, and we tried to find what are the fact patterns, what is the information we can extract that will be useful. So let's look at, first of all, what is the underlying causes of actions, and we found 5 patterns. Either the taxpayer does not want to abide by the tax laws. So tax law says pay your VAT in this way. Taxpayer doesn't comply. The second one is the taxpayer simply pursues an unreasonable position. The third is the tax authority has made a mistake. I've seen this in 2 cases. The fourth is there are facts in dispute, as we've mentioned. And the fifth is that there are doubts as to the interpretation concerning doubts as to the interpretation of tax laws. Now, if you look at these 5, and this all we saw fell into one of these categories. Of the 5, only the last one is actually unsuitable to go to an ADR track, to go to negotiation or mediation. If we can go forward, please. Let's take a closer look at each band, that is band 1 to 4. So for the first 2 reasons for filing a tax appeal, taxpayer does not comply with tax laws or pursues an unreasonable position. If we go to the next one now, what this tells me is that there is a high taxpayer culture of simply challenging tax assessments frequently. That could either be as a result of distrust of the system, or it could be the result that the tax authorities are pursuing a strategy that is too aggressive. I'll give an example. The variances we see in an initial tax assessment and a negotiated settlement might tell me that, well, why didn't you pursue that reduced tax assessment in the first place? So it could be that the tax authorities are overly aggressive, which causes the taxpayer to dispute that particular assessment. But in disputes like this, it's suitable for ADR as we'll see. Let's go forward, please. Now, if we look at the category of a mistake from the tax authority, this has no business, to my mind, going to TAT, going to any adjudicatory process, because the tax authority, when it becomes clear that it has made a mistake, should own that mistake, right? And the mistakes could fall into one of two categories. It could be that an adjudicative body like the TAT is unlikely to uphold it, since that mistake does not accord with the law, in which case there is no basis to file it. Or it could be simply an inadvertent error. But again, once you discover it, then there should be internal mechanisms to resolve it. It should not go to the TAT. Let's go forward, please. Now, the one that I said is unsuitable is disputed, So this category now deals with disputed facts or doubts concerning the interpretation of tax laws. Now, there is a solid case here for these ones to go to court. If, like I said before, if the facts are heavily disputed, then you might want that adjudicated mechanism, that sort of balancing of the facts to see which one is more credible. And it could be also that the facts are so intertwined with the law that, again, the response should be to send it down the TAT track rather than the ADR track. If we can go forward, please. So let's evaluate the data. Okay. So like I said, we looked at 73 published decisions. Now we're looking at duration. 22%, I'm sorry, of those were decided within 1 year. 30% within 2 years. But the vast majority, 48%, 3 years and above. Okay, so what's that telling us? It's telling us that for the vast majority of cases, sorry if we can go back. For the vast majority of cases, the duration it's taken defeats the purpose of the TAT. Because now what's the alternative? If it's taking me 3 years to resolve a dispute at the TAT, and I have to face another 3 levels of adjudication, then to me that system is not working. So that's a figure that we should all be mindful of. So let's go forward. Okay, now let's look at the use of negotiation. Of those 73 cases, 22 involved negotiation, right? 30% of those, oh yes, so let me just read that portion of, okay. In 22 of those cases, negotiation was deployed. That represents 30% of the total cases, okay? But in 86% of those cases, there was a successful settlement. So another question, if negotiation is so successful, why isn't it being deployed more? So that's why it's important for tax commissioners to be able to see from this fact pattern, we can send this to negotiation. If we send it to negotiation, we know that there's an 86% chance that it will come back with a negotiated settlement, but we'll still see some data as we go along. Now, we also looked at the duration of cases involved in negotiation. And on average, it took 26 months, but that figure is misleading because it takes into account the entire proceedings. And what I mean by that is the time it takes for the parties to file the proceedings, exchange papers, and then there is an offer to say, okay, let's talk. So they will talk, they will settle, they will file terms of settlement, there might be another period before it adopts those terms or the parties discontinue proceedings. So if we isolate only the part of when the parties talk, then we saw that the average duration was that they will settle in 6 months in comparison with 26 for the whole proceedings. So additional 20 months, like I said, it's these other aspects of the proceedings. So what that is telling me is that it for the TAT to devise a procedural system that rewards the parties when they decide to exploit and when they settle timelessly. So from the cases we read, we saw that the delays were because, well, start immediately. There was a period between the filing of the case and when the discussions started. We also saw some cases where, like I said before, the tribunal actually was not satisfied with the party settlement. And the one that stands out was where the parties didn't take into account mandatory provisions of the VAT Act. So in that case, we can't accept this as agreed terms of settlement, so they had to go back. And then adjournments between the filing of the terms of settlement, and also we saw in 2 cases that the tribunal had to be reconstituted. So that again took up quite a lot of time. If we can go forward, please. Okay, so these slides sort of show the differential between initial assessments and negotiated settlement. So in this particular tax appeal, the difference between the initial assessment and the negotiated settlement was 136 million naira. So again, you should ask, are the tax authorities too aggressive in their assessments, or what is the reason for this? Is it that they are deploying it as a negotiation tactic to say, okay, let's pursue high assessments in the hope that they'll come and sit down, we'll propose a figure, and they'll say, well, 63 million is better than 200 million, we accept. Could be, but these are inefficiencies that the system as a whole needs to address. Okay, so can we move forward? Another example of a Keystone Bank and Kaduna Internal Revenue Service. This time, the difference, huge, 276 million naira. So the initial assessment was 291 million. The negotiated assessment of the negotiated settlement was 15 million. Huge. So if one wonders if there was a more, and I hesitate to use the word liberal, but if there was a less aggressive assessment, would there have been a referral to the TAT? Okay, let's go forward, please. So let's look at the difference between, okay, yes, this one shows the differential between the assessed amount, the initial assessed amount, and the negotiated settlement. So what we find in the cases involving negotiation, the average assessment, and it varies broadly, but the average was about 354 million. After a negotiated settlement, it dropped by about 17.2%. That's the average drop. But in some, like you've seen before, that drop is significant. With these ones, you can say, okay, yes, this seems more reasonable, 17%. That's the average drop we're seeing. If we go forward, please. Now let's compare negotiated settlements with regular proceedings. So like I mentioned before, if you isolate only the portion of the proceedings that the parties discuss settlement, they will generally settle within 6 months. Go forward. If you compare that to the average duration of regular proceedings, then it's 316% less. For regular proceedings, 6 months for negotiated settlement. So regular proceedings will take you 316% more time than if we isolate the negotiation portion alone. Go forward. Again, if we compare the average settlements, so please go forward. Now, this is where we're seeing massive differentials. The average assessment after negotiation, which the tribunal tends to accept in consent judgments, the average is about 293 million. If you proceed down regular proceedings, then the average assessment that results in the TAT's judgment is 12.2 billion. So if the parties wanted a case to say, okay, I think you should look at negotiation or mediation as an option, that's the case right there. It will cost you over 4 on average to fight it out here than it is to say, go and negotiate, and you can do it within 6 months, come back, have a consent judgment, carry on with it. Next slide, please. Now, what do we do with all this data? It's one thing to know it. How do we implement it? I like the UK example. So in the UK, the UK has the first tier tribunal, which is the equivalent of the tax appeal tribunal. Now, I had a look, and I speak under the control of each tax commissioner here, but I had a look at the rules, and I didn't find any provisions that require tax commissioners to refer parties to an ADR track. I understand that it is a policy of the TAT, but I didn't see any provisions in the rules or even practice. If we look at other jurisdictions, so the example I've given here is Rule 3 of the tribunal, the first tier tribunal rules. This is the tax chamber. So it says the tribunal would, where appropriate, bring to the attention of the parties the availability of any appropriate alternative dispute resolution of the dispute, and if the parties wish, and provided that it is compatible with the overriding objective, facilitate the use of that procedure. Okay, so the first tier tribunal will not only draw your attention to it, they will also facilitate it to ensure that you're coming back and you haven't wasted your time. Okay, so one thing we could do is to start developing actual policy in terms of a rule amendment or a practice direction that requires an assessment, an initial assessment to say, is this dispute suitable for a negotiated settlement, mediation, and I will discuss arbitration shortly. Is this suitable? If it is, bring it to the party's attention, but don't leave it there, because you don't want a situation where the parties go and settle, but they've missed something, like we saw in one example. They've missed a mandatory provision of the law. The assessment just looks too suspect. So there's this process of facilitating it, not facilitating in the sense that a member of the TAT is the one mediating a settlement, but facilitating it, to my mind, in the sense of providing the parties guidance to say, if you follow this template, then you are more likely to succeed. Okay, if we can go forward, please. Okay, now if the first tier tribunal in the UK proposes ADR and parties accept it, then they will stay their proceedings for 150 days. Generally speaking, 150 days. There is scope, if it is appropriate to do so, to extend that time. We can adopt a similar thing. So the 150 days is about, give or take, just less than 5 months. Just less than almost 5 months. Now we know from the data that it will take them 6 months, generally on average. So we can say, okay, 150 days, 180 days, we are prepared to stay these proceedings. And not only are we saying, okay, go and settle, because, and I speak as a member of the bar, I know how lawyers misbehave. Go and settle, they will not do it. They will come back and say, my lord, this happened, I was sick, and they will not settle. So there needs to be a mechanism to facilitate their discussion. Okay? And sorry, just go back. I just want to touch the third point. Just go back. Yes. So when the parties wish to use ADR, the tribunal will only stay the proceedings if it is satisfied that the hearing will go ahead if ADR does not succeed. So there is active case management here. There is active case management. We will facilitate this for you to ensure that you do succeed. But this is the hard stop right here. If you come back and there is not a negotiated settlement, we are proceeding. Whether you are sick, whether you lost your dog, whatever happened, we are proceeding. And the argument most lawyers use, say, oh, fair hearing. It's like our unruly horse. Absolutely. It's our unruly horse, But provided that the tribunal has given an opportunity to be heard, then it can't be said to have denied fair hearing. So that's something to be mindful of. I think the TAT, and indeed all courts, should be a bit more brave in saying, actually, you're taking the mickey. This is a bit too much. This is where I draw the line. And in order to fulfill my mandate as an alternative to the court system, and in order to ensure minimal disruption in terms of time and costs, I need to be as efficient as possible. And what you are proposing is not efficient. So in other words, the TAT is controlling the proceedings, not the lawyers, which tends to happen. Okay, if we go forward, please. Okay, so how do we maximize the efficiency? Because as we saw, yes, it takes 6 months to settle, but when you now tie that in with the entire proceedings, it takes an average 26 months. So how do we then maximize that 6-month efficiency? Well, the first one we've already discussed, active case management. Encouraging and facilitating the party settlement, but telling them and in place, say, when you don't settle, we are proceeding, and this is our hard stop. Okay? And in terms of facilitating it, because sometimes the parties may miss this, but the TAT is an expert tribunal. So the TAT, there's nothing stopping the tribunal from saying, okay, if you're going to settle, these are the salient facts as I see them. These are the issues as I see them. In settling, you need to be mindful of these provisions. You cannot deviate from this. So whatever your settlement is, you cannot contract out of these provisions. You're facilitating a successful settlement. So they will come back and say, actually, you should have paid attention to this. That's not efficient. That will turn your 6 months into 26. Then there needs to be a provision to minimize delay between the actual settlement and the consent judgment. Other jurisdictions, and I was looking at this, other jurisdictions have, for instance, draft orders. So in the UK, if a party files, if the party is settled, they can actually file a draft order, and all the judge needs to do is put a signature. It sounds tenuous when we look at some of our jurisprudence to say, well, no, it's the judge. The judge is the decision-making authority. So why should we transfer that to the parties? You can control that. So if in the TAT rules, there are templates to say, if you settle this, in addition to your terms of settlement, file this draft order. So again, we are saving time, right? So all the judge needs to do, or the commissioner needs to do, is scrutinize it, it complies, or even at the stage before it gets to the commission, if there is an efficient registry, they scrutinize it to say, yes, it complies. Bring it before the commissioner, it's signed. That's your judgment. In terms of delivery in open court, well, yes, that could take place subsequently, but there is a binding judgment upon its signature. So that could be one way. Another way is to incorporate time limits or a timeline as a guide to the parties to say, okay, if you settle, it triggers this time limit, and there has to be a consent judgment by this date. Okay, so if we, I think that might be the, yes. So I just made some concluding remarks there, but I didn't want to stop without touching the issue of arbitration. Is arbitration, is our taxes, please forgive me. Maybe I'm the one who needs to lose now. Are tax disputes arbitrable under Nigerian? Yeah, simple. The answer is no. We understand that. There's a Court of Appeal decision that says no. Let me ask another one. Should tax disputes be arbitrable on Nigerian? To me, yes. To me, yes. And I understand that this invokes a lot of controversy, a lot of debate, but let me give my reasons. So I've heard several reasons as to why it should not be arbitrary. The first is exclusivity under Section 251. Now, the reason I disagree with that is it's going to set a dangerous precedent, one, because if you say tax is not arbitrable on account of 251, it means nothing under 251 is arbitrable. So if you look at any commercial dispute that goes to arbitration, guaranteed, there will be a relation to 251. So mining, intellectual property, etc. Thank you. Aviation, banking to an extent, yes. There will be a 251 connection. So we're essentially killing the practice of arbitration in Nigeria. We are making Nigeria an unattractive seat. So I don't like the 251 argument. But I don't think 251 was intended to exclude arbitration for two reasons. Primarily, it says the Federal High Court's jurisdiction operates to the exclusion of other courts. So is an arbitral tribunal a court? There is a decision, actually, I think it's from, is it Uganda? There's another African, and there's one from India that says it can be referred to as a court. But we have constitutional provisions that define lists, primarily lists what our courts are, and then says you can establish other courts by acts of the National Assembly. An arbitral tribunal is not established by an act of the National Assembly, but by the parties' agreement. So I don't think that exclusion applies to arbitral tribunals. The final one is if you look at the Federal High Court Act itself, it gives the Federal High Court judges scope, if the circumstances are appropriate, to refer their disputes to an expert or an arbitrator. So if 251 was intended to exclude arbitration, then why give the powers to refer that same dispute to an arbitrator? So that's why I don't like the two. I don't agree with 251 argument. The other aspect I've heard, and it comes from sort of a distrust of the arbitral system. Can we trust the arbitrators to arrive at the correct decision? Again, I don't see any reason why not. Let's look at examples from other jurisdictions. The European Union. One of the most heavily regulated areas under EU law is IP, intellectual property. There is a specific regime for it. There are specific courts to which those disputes go. But if you look at the decision of the court, CJEU, the Court of Justice of the European Union, in United Colors of Benetton, it says, well, yes, we understand that there is a specific regime for this, but that regime doesn't make this dispute inarbitrable. The only thing that would happen is that if the arbitrators fail to apply EU law, then it becomes contrary to EU public policy, and that decision is liable to be set aside. So, in other words, there shouldn't be an apprehension that if the tribunal gets it wrong, that's the end of the story, because there's another level of control. The courts can scrutinize whether this award complies with our public policy in this heavily regulated area. Another jurisdiction is the US. Antitrust, competition, heavily regulated, provisions to send those disputes again to a specific court. But there's a decision of the US Supreme Court in Mitsubishi Tires versus Soler that gives exactly the same rationale as the EU courts. To say, yes, heavily regulated, but it's arbitrary. If the tribunal gets it wrong, it's contrary to US policy because it contravenes mandatory positions or provisions of US law. So, to me, I think there is that in the system to say, well, we're not sure that the arbitrators will get it right. But I think what we need to sort of establish is that there is another level of control. And I understand there is still apprehension because I've been on the receiving end of it, that sometimes the courts might not even agree with you, particularly where, and forgive me if there are any federal government representatives here, but where there is a state element involved, the court becomes very apprehensive to make a decision that will negatively affect that body. So I understand the reasons behind it. I can understand if the system is weak and it will arrive at incorrect decisions, and yes, we should do something about that. But I think that the notion to say that it is inarbitrable carte blanche, we should rethink that. But what we should focus on is ensuring that there's capacity in the system to determine these types of disputes. So again, I'm mindful of time. I hope the presentation actively touched your attention deficit, and I'm grateful for listening. Thank you very much indeed.
Thank you very much, Mr. Bosima. I believe that was a thought-provoking presentation. Please, let's appreciate him again. Please, do we have questions for him? Questions?
Thank you for your presentation. When you were banding the numbers and figures, I got interested from that point of view. Looking at what happens when they go the length of the hearing or the litigation, however you want to call it, or where they go to settlement or negotiations. The issue I always have is that one, we appreciate that it is the case of the appellant and thereafter the case between the parties as they have brought it before the tribunal. It's not the tribunal's case. The tribunal is not bringing in issues, questions, or areas for them to touch. Likewise, it is for them to determine whether they want to discontinue and where they settle for them to determine what the terms of those settlements will be. Now, there is a risk because the issues before the tribunal are twofold: issues of fact, issues of law. Clearly, as you have said, you can settle and compromise on factual issues, but mandatory provisions of law are mandatory provisions of law. Now, there's a risk that the parties may use the tribunal as an instrument of fraud, because where you find an initial assessment at 2 billion and thereafter a settlement comes and they say it's 28 billion, and they reduce it to terms of settlement, and you are meant as a tribunal to enter it as a judgment of that tribunal, and we all know what that means, enforceable thereafter as a judgment of the Federal High Court once it is registered. Then that takes that settlement, regardless of the content, especially where there is no scrutiny or there is no input, it gives it a life of its own. So what is your own feeling as you encourage this idea that we should promote settlement and negotiation because there's more money that comes out of it, or it's quicker or it's speedier, when you pitch it against the risk that the tribunal can be used as an instrument of fraud?
Thank you very much.
Yeah, thank you very much. That was a very beautiful presentation. I particularly like the empirical analysis that you have brought out in your presentation. I must say I'm quite impressed. Thank you very much. Now, on the issue of Section 251 of the Constitution as a bar or a challenge to arbitrability of tax disputes, that cannot be so and cannot be a correct argument. Otherwise, TAT itself will be caught by the provision of Section 251, because we are an administrative, we have been held to be an administrative tribunal that can exercise jurisdiction prior to assessing the jurisdiction of the Federal High Court pursuant to Section 251. So that cannot be a bar to arbitrability of taxation. In my view, and as you have rightly pointed out, there's actually a Court of Appeal decision to the effect that taxation on public policy consideration is not a dispute that parties can agree and say, look, let's pick our mutual friend, a sole arbitrator, and determine on matters that touches on the revenue accruable to the federal government and which directly or indirectly touches on the survival of the state. We are a developing country, and I doubt if federal government is going to submit that jurisdiction to a non-state entity. Yes, we can make reference to America, to UK. These are advanced economies, absolutely. But a multinational, an IOC, has been served an assessment of $5 billion US, and FRS is waiting. FARC has written to FRS that, look, I mean, we need revenue to do this. And Nigerians are waiting as well. And we imagine that the IOC and FRS will say, okay, can we appoint Mr. X or a 3-man tribunal to look into this and determine the liability on this? I think our system has not developed to that stage. So it is hoped that in future that we'll get to that level. I don't think we're at that level. Thank you.
Thank you, sir.
That's the last intervention.
Thank you very much.
That's the last.
No more. Okay.
After yours.
Okay, thank you, sir. Mr. Bozimo. Incidentally, I walked in at the tail end and you were discussing a very important and interesting topic to me. I represent Nigeria in the inclusive framework, working with the G20 and the OECD on the 2-pillar, and one of the major issues we have been having with respect to Pillar 1 is the issue of mandatory arbitration for tax purposes. And Nigeria has said no, and we have been leading other African countries and other developing countries to say no. And so it aroused my interest when you were speaking about it. And I think I will join my brother here to say that arbitration for tax purposes would be a dangerous path to the church for now. For many reasons. I have been interested in arbitration for some time. I'm not a lawyer, but just going through judgments. And I've seen that in most developing countries that have submitted itself to arbitration outside taxation, they have never gotten a fair deal. And the P&I deal, which we explained starting last year about, is one example of how we could put our finger in the hole of this coffin. And so for me, I don't believe, one, that we have the local expertise. I also don't believe it is morally right for us to submit our tax law to the law of another country. Because most of this arbitration, they don't happen enough. They don't happen under our own law. So, number 3 is even the cost. If you're going to have to attend arbitration in London, for example, you need to fly lawyers, you need to fly documents. It is, for me, a no, and a no. Thank you.
If I may, I'd like to start with the last 2 interventions. We actually agreed on that point. We actually agreed. So the distinction I was trying to make, was the Court of Appeal's reasoning from the first decision, that 251. I don't think it's a valid argument. I agree with you entirely when you say, for instance, there are certain disputes which, from a public policy perspective, should not go to arbitration. Now, cast your mind back to some of the slides I put up. There were 5 categories. 5 categories. One of them concerned interpretation of laws, interpretation of tax laws. And if you recall, I said that that is not proper, if you recall. Now, the decisions, the Court of Appeal decision specifically, the second one, that drew a distinction between contractual disputes and tax disputes, said a tax dispute concerns the operation and interpretation of tax laws. So we're agreed on that point. I also don't think certain disputes before private tribunals. It's a big question in investment arbitration, for instance, where you have exit tribunals in Washington that are determining policy of states, and it leads to what is known as a regulatory chill. So 2 examples in Africa. South Africa, as a result of a decision from the parties are called Piero Foresti. So what happened there was they implemented legislation because of the Black Empowerment Program to give more opportunities to Black South Africans. That involved in the mining industry. So one investor challenged it to say that legislation has expropriated my investment because it's taken my investment and now spreading it more equitably, if you like. And the exit tribunal agreed. And for that reason, South Africa pulled out of most of its BITs. So we're on the same page. I agree with you. What I'm saying is that there are we should be careful as to how we formulate the argument, because there are certain other categories. If we go down that 251 argument, it will affect other areas. So same outcome. I just said, let's take a different approach. Mr. Ajibola, thank you for that very, very good and pertinent question. Now, if I can give an example in arbitration, because that's my field. Now, there is a provision in the ACA, the Arbitration Conciliation Act, that says if the parties settle their dispute, then they have the option of presenting it to the tribunal for a consent award, but only if the tribunal accepts it. And the reason for that is money laundering. So what has happened, parties will make up a dispute, settle, have an arbitration award, and all of a sudden, because of the New York Convention, it's enforceable in over 150 countries, right? But the provision I want to focus on is that if the tribunal accepts it, because the tribunal will pick up on it. Now, as a body of expert tax practitioners, you will be able to tell when something is not right. So, I'm sorry, my time is right. Okay, sorry. Yes, I will end now. But from the decisions we scanned, there were only 2. There were 2 where the tribunal said something is not right here. So the capacity is there, but it shouldn't stop the encouragement in appropriate cases for use of ADR. I think the advantages are there. We just need to harness it to make it more efficient. So I'm happy to answer more questions off the stage, but I understand time is running out.
Thank you very much, Mr. Bosimo. We will quickly go into the next thing. Our time is fast spent. Okay, there's an award to give it.
Thank you very much, Mr. Bosimo. On behalf of the commissioners, chairman, and the secretarial staff of the Tribunal, thank you very much for your work on that paper. I'm happy that you find our website very useful in bringing us your presentation this afternoon. to ensure that our chairman and commissioners find your presentation useful. I will have something to take home from this presentation to improve our performance at task force. Thank you.
Once again, our sincere apologies for the questions we couldn't take. The next paper is taxation of oil and gas in Nigeria, an overview. And the presenter is Mr. Gabriel Olajide Ogunjemilusi. Mr. Gabriel Olajide Ogunjemilusi is a fellow of the Chartered Institute of Accountants of Nigeria and an associate member of the Chartered Institute of Taxation of Nigeria. He holds a master's in business administration. His experiences in tax administration spanned over 2 decades, and out of which he has put in over 17 years in oil and gas taxation. He has attended various trainings, workshops, and seminars on taxation, both within and outside the country. He has also presented papers on oil and gas taxation at various workshops and seminars. He served as a member of the Executive Committee on Petroleum Industry Bills, National Technical Drafting Committee for 2019, Finance Bill amongst others, National Tax Policy Reform Committee for 2020 Finance Act. He has held various positions in the Federal Inland Revenue Service over the years, such as Tax Controller, Oil and Gas Upstream, Head of Audit, Oil and Gas, State Coordinator, Lagos Island and Director, Tax Policy and Advisory Department. He's currently the Director, Large Taxpayers Department, Oil and Gas of the service. Mr. Ogunjemilusi is happily married and God has blessed him. Please kindly help me welcome Mr. Ogunjemilusi.
Thank you. Good afternoon or good evening. Ladies and gentlemen, our protocol duly observed. Let me appreciate the coordinating secretary of TAT for giving me this real privilege to come and present this paper. Just like the previous presenters, I'm not a lecturer, I'm not a teacher, I'm just a bloody tax administrator. So just we are going to go through it. I know oil and gas is a topic that at the time can be very, people see it as very complicated and difficult, but it is not. By the time we go through it, I think will give us better understanding. There's nothing we can take, even in the next 10 years or 20 years, irrespective of what the International Committee has said about oil and gas, I believe oil and gas will still be very relevant. At least the issue of fossil oil and all those, you know, the cost to present, to prepare, to get it ready, cannot see on the high side. So we need to look at this area because it's what particularly is going to give us a lot of money. And if you go through the cases that are before the TAT, when you look at the amount involved, oil and gas cases are counted for the huge sum of money. And they are very, very important to us to understand. Thank you very much, sir. So the paper is just go to the next slide. The objectives are stated herein. Next one, next slide. We are going very fast. The objective, the oil and gas sector play. Madam, the one I sent to you this morning, you did not project it. Madam Oninyagi. Thank you. The oil and gas sector play a vital role in the development of this nation. It accounts for the lion's shares of the revenue generated and thus remain the spotlight in the estimating, collecting, and recording revenue generated either through crude oil sales, royalty or taxation,
So this presentation seeks to educate participants on the general overview of oil and gas transition in Nigeria. That's just the objective of the presentation. Overview. The oil and gas industry is very categorized into 3 sectors: upstream, downstream, and services. But in the PIB, when it is passed now, we are going to have upstream, midstream, and downstream. So we are not going to have service. Service is just the classification we give to it in FRS. We have midstream, and we have upstream and downstream. In the PIB, they are going to be upstream, midstream, and downstream. So the activities of the oil and gas industry range from the search for the crude oil and production and the lifting. Next one. So we have the fiscal regime. I just bundled of mechanism or tools used in extracting government here. Call it government take through the lifespan of an oil and gas project. It entails all government take in cash or kind throughout the project life of the oil and gas sector. That's government take. What is the share of government in this? So that's what we use fiscal tools to get. Choice of mechanism tool depends on sharing of risk and reward. PSC or social, we are going to go timing of government revenue or a combination of both. Fiscal tools, we have the signature bonus, we have royalties, profit taxes, taxes on cost and input. That's what we have your, okay. Then the government fiscal objective. Next one, so that I can just take the break. Fiscal regimes, these are just the tax they use. We have petroleum profit tax, value added tax, and any other. Then deep offshore inland basin and production contractor. Those are the 2 specific that are specifically for upstream. The others fiscal regimes are also applicable as to the industry. Next one. Regulatory agencies. The oil and gas sector is the most regulated industry in the sector in Nigeria. There's no doubt about that. We have a lot of regulatory agencies, and just mention some of them: the Ministry of Petroleum, Department of Petroleum Resources, NNPC, NAPIM, CMD. You have local content. You have NDTC. You have many environmental impact. They are there. Next one. The structures of the oil and gas industry. You have the oil and gas industry, you have the upstream, you have the exploratory and production. And you will have sales, the lifting, they must sell it to get money. The downstream, you have refining, marketing, and servicing. The oil and gas, the upstream sectors of the oil and gas industry is currently the most important sector in Nigeria and account for over 90% of Nigeria total exports. Apart from giving all revenue, is also accounted for largest in export. Companies operating in these sectors are involved in the exploration and production of oil and gas. Their major activities are exploration, mineral rights acquisition, seismic, and all those one. Major features of this comprise the business is highly capital intensive. The risk is very high. Takes a longer year to even the gestation period is very high to discover oil and to start making money. Different business arrangements are there. The tax regime, petroleum profit tax, are deep offshore, and so on and so forth. Then complex tax reporting. The details of taxes are very complex and voluminous. Next one. The downstream, that's just the element of the refining, petrochemical, marketing, distribution, and service and support. They are downstream. The midstream presently is subject to tax under PPT. I had to do with this pipeline transportation when that's with inlet fees, where it involves crude oil. Next one. Structure of the refining operating under this category are involved in refining process of crude oil into different white products. Marketing, just the sales of the at retail end, those ones that are selling the white products to the filling stations and the line. Then services are the companies that are rendering services even to the oil and gas industry or the upstreams. So they are interwoven somehow. The income of one is able to be the expense of another one. So that's some activities of the companies in these categories are similar with upstream companies. The major difference is that these companies do not have any title to an oil license unless we are such a company undertake all exploration and production activities of the license holder for a fee. Then such company may be classified as service contract companies under the upstream. So their service contract, they invest, they spend all their money, they do a lot of things as if they are doing the exploratory. But when they are exploring for on account of another person, they are not seen to be in petroleum operations. They are just running the service, so we call it service contract. Next one, those ones are very important when it gets to the issue of fiscal policy to apply. And licenses, I don't need to bother myself about this oil exploration, OAPL, OML. Next one, because of the time we need to rush. Oil and gas sectors, especially the upstream sector, is characterized with commercial arrangements. They are very important and they play a serious impact. They have a tremendous impact on the taxation of the industry. So we have commercial arrangement upstream, we have concessionary ones, and we have a contractual arrangement. Concessionary ones are the joint ventures, the sole risk, margin at the end. This is when they own the equity, they have equity in oil block. Concessionary when they have equity in the oil block. The other one contractual is one the concessionaire gives the oil block to someone to produce for his account. But there's another one, the production contract in Nigeria is designed in such a way that even coming up with the Deep Offshore Energy Basin Act of 1999, the commercial arrangement finds its way into the physical. So there is some kind of commingling of commercial arrangement with physical arrangement, which gives a lot of difficulties in the administrations of deep offshore energy basin tax. And that's why we are having so many cases before the TAT. The next one. They don't go. Okay. Out of my minutes. Maybe I can stay here so that next time I can go. You don't finish. But you can't get the sounds to connect. This is okay, sir. I think I've left this place downstream. Fine, it does. Okay. Okay, I'm here, the structure, but it will not be seen that's another papers. Thank you. No, it's in the document. So the commercial arrangements, as you have a joint ventures. I just speak to them one by one. Joint venture, that's where the two parties come together. They both own the concession. They have equity participation in the oil block, and they also share the reward. They share the risk and the reward according to their equity participation. So they contribute to the production exploratory activity to what they call cash call. Just the one that we have majorly between Nigeria and the NNPC, we stand for the federation and the IOCs. There are some that involve individual operators too that are they are into joint ventures. And this one is majorly under the PPTA Act. And they are majorly onshore. That is the one that are done on the onshore or the water depth of up to 100 meters water depth and 199 meters water depth. That's shallow water, because never share and shallow water. Production contracts is administered under the Deep Offshore Energy Basin and Production Contract Act. Production contract is a commercial arrangement, but in Nigeria, they have also made it to be part of a physical arrangement, which should not be, but there is a specific rule. This one, the oil blocks that fall below 200 meters water depth are the one that own sharing contract, deep offshore sharing contract. There are some that are onshore and water depth of 200 up to 200 meters that have production sharing arrangement. They are not covered under the deep offshore basin production sharing contract.
So the incentives that the producer are not, they are not entitled to it. Then we have product sharing agreement, which is between individuals. It's a deep offshore also, but between individuals. Not government is not involved. The first one, PSC, is NNPC involvement. They own the concession and give it to a contractor who explore and produce from the oil and from the field and recover its costs from the production. And they share the profit. They call it profit sharing ratio. The sole risk are the individuals that own on the onshore, and a sole risk, we don't have any sole risk in the deep offshore now. That is solely the one that is carrying the risk. It can happen tomorrow if somebody has the money and can get an oil block. I don't know it. I don't think there is any law that say government cannot give deep offshore to an individual. I think we have one already, but later the government what call it fanfare. That's a given to this our lady, the richest woman in it's a voluntary contract, deep offshore, but she entered into agreement with Chevron, and that one is producing. Government tried to exercise backing right. They went to Supreme Court and they won the case. And on the basis that they did not follow the due process to exercise the backing right since 2012. Until today, we have not followed the due process. Don't see us. Then we have the marginal fee. These are the unproductive field to the IOCs. They think that it is not commercial enough to them, so they are not exploring there. And at a point when government realized that they were just sitting on acres of on oil that could have been produced, they now forced them to relinquish that marginal fee to indigenous oil companies. We have a lot of them operating now and they are producing, but unfortunately the tax that we are getting there is very, very low. Not Nigerians, we don't like to pay taxes. So then we have service contracts. Service contract is just it's a risk. It's a risk-free something to, someone takes the risk on behalf of another and just rendering a service to him, which he will get paid as a fee. It can be in kind, it's usually in kind, and it recovers its cost also. But this one, like the PSC, it takes fees, so it's liable to start under company's income tax. The other ones, they are liable to tax under petroleum profit tax or deep offshore inland basin act, as the case may be. Overview of now we have the petroleum profit tax is chargeable on the profit of companies engaged in petroleum operations. Petroleum operations have mentioned that those are the companies that are winning and obtaining crude oil for and on his behalf on his own account. So any barrel of crude oil produced is liable to PPT. You must lift it. Where you lift the crude oil is liable to PPT. You must account for PPT. And you usually account on the equity owner. Only the person that owns the equity crude is the one that we account for PPT. Except for deep offshore, that there is some kind of the law amended in such a way that the contractor lay claim to the PPT paid. Because the law says that the receipt must be split between the concessionaire. That's where we have that. The things we have a lot of cases like that before TT now. And why is it? Because DPR, the NAPITs are not advising, it's not advising FRS as to the ratio of the profits or split ratio. That's only where we have a situation where the owner of the crude will not be the one to account for the tax for that he pays. We have other things that we are going to speak to later. So petroleum production is also a measure and defining there is in the law. I said that. Let's go to chargeable income under the PPT. The proceeds of the crude oil sold is chargeable. That's section 9. Produce of crude oil sold. Produce of crude oil disposed. That is, when you dispose, you do not. There's a definition that the interpretation that define what disposal means of crude oil. That's disposal without sale. When you use your crude oil to meet an obligation, it is, you are still going to want to account for the tax for it because you own it first before you can use it to pay for anything. It's only on the deep offshore land basin that is not accounted for in that wise. We have other things we have under this marginal alternative funding arrangement. You have modified carrier agreement that we have an issue there now, which some of them are before the TAT already, and I'm sure others are still coming. So it is value of crude oil, chargeable oil disposed. When you do not sell it, you take it to your refinery to process. You will account for the PPT on it first. Or you use it to pay to meet an obligation. Somebody did render service to you and you give your crude in the settlement of that service. The person that is giving the crude must also account for the tax on that crude oil. Then the next one, the companies come, I don't need to tell too much on this. It's just like the other company income tax. Income, if a company is into exploratory activities and yet to start production of crude oil or start to lift, is still under the company's income tax act. So whatever income that it makes outside the winning and obtaining of crude oil through extractive and all those sorts, you pay it on it. If someone sells crude or someone buys crude oil and resell, it's not the one that produces it. That's why the fact that it's dealing in this buying and sale of crude oil, that such a person or a company is not liable to PPT. So it's just liable to SITA because it's not winning and obtaining through extraction. It's just buying it to resell. Then another thing there, I'm trying to beat the time. The other one I talk about is filing, which is the PPT is due for filing 5 months, not later than the end of May of every year of the following year. Then we have estimated tax returns which must be filed every February. Start making payments on instrumental from March. It's usually on actual year basis, so to say. We only have 60 days lag. The income of January, you pay tax on it on estimated tax in March. SITA is just like any other one, so I don't need to pay for that. Then I have incentives in the oil and gas industry. There are some incentives granted in the PPT. Presently, we have for the first, when the company is yet to absorb its capital allowances, it will be entitled to subject to tax at 65.75% for onshore. For onshore, PPTA is 85%. For deep offshore, is 50%. And you have an ITC of 50% for contract signed prior to 1st July 1998. Then beyond that is a 50% ITA, investment tax allowance, or 50%. We have a zero rate for natural gas transfer into gas to liquid. It's at 0% PPT rate. Then the gas produced, associated gas produced with oil, is usually subject to tax under company's income tax at 30%. And the cost of all the costs, CapEx incurred to produce the gas is charged to oil development costs. It's an incentive. So you charge all the costs into oil development costs and the tax under 85%, while the income earned is subject to tax at 30%. We have investment loss carry forward indefinitely, no restriction. All investment doesn't have mentioned that. Okay, those are the incentives just to rush it fast. Then for gas, downstream gas utilization, there's also incentive for that gas utilization, which we tried to amend on 2020 Finance Act. The other presenter mentioned it, as I said, I will speak to it briefly. What informed the amendment in 2019 first, we amended in 2019, was the idea of companies that have enjoyed upstream gas utilization incentive, that they want to come to downstream and start enjoying something, because there's nothing that stopped them in the law. So they were taking advantage of it, and we said, if not, that's why we amended the 10. And we said that if you have enjoyed incentive in any act, that time we don't mention any other act. We are looking at something that now we expanded it in 2020 Finance Act to cover any other act, LLNG Act, DPPTA. If you have enjoyed it, you can come to Section 39 and claim it. Another reason why we amended 2020, we made further amendment 2020 was the issue of this expansion gas project, where the government is saying that very soon maybe all our filling stations will be selling gas. They want to use more of more clean energy. So the moment they are selling gas, if you don't change the word company to a trade, every company that had been paying taxes before, if they now start one small outlet that they are doing sales of gas, they are qualified to benefit under Section 39. That's why we are amended to change it to trade. It's not the trade of that gas utilization that will benefit, enjoy the benefit, not the company as a whole. So we are proactive in that. That's why I said the issue of finance act is very, very important. Because if we want to do holistic tax reform, to do amendment, we may not get through it. The finance act now wants to react to situation as it comes, or the one that we're anticipating. We can think ahead and block it so that we don't have the block. Thank you, sir. So there starts on the day of 3 years under Section 39 for a gas utilization downstream, and you have 35% in allowance. That's one. Two, you have also additional investment allowance of 15%. But anyone that takes 35% investment allowance cannot take additional investment of 50%. And there's a related capital allowance of 90%, which is retention of 10%. The dividend distribution during the period, it starts holiday and free. Duty on VAT, all the equipment import for VAT, for gas utilization of machinery equipment, duty are exempt from VAT. I'm rushing the time. So the Finance Act 2019, the Section 60 of PPTA was amended 2019 Finance Act. The Section 60 is the one that has stopped any FRS from charging tax on any company on any profit that has suffered petroleum profit tax. Be it PIT, CETA, is the moment a profit suffer tax, PPT, we don't charge it to, and that's why dividend then was not charged to withholding tax. And it was saying that some of the companies that are now in Nigeria have your profits from the oil and gas industry. When you take your dividend, don't tax it. But budget amendment done in 2019, those are now liable to tax. But there's a gap because profit now that is shared by under the production sharing contract, under the profit sharing profit oil is now going to be liable to tax. That's another challenge we are taking up with them. And they are saying that we are distorting the arrangement. The commercial arrangement that brought them in, what their economies they ran when they came for the investment was we never considered the issue of dividend. I'm almost at the second to the last one. Yeah. Next one. Yeah. So it's that one is another thing that is coming up. In the PIB now, they fought it to say that they should restate. They should give them that leeway not to tax, subject them to any other tax after you have subjected them to PPT. But the government is not taking that from them. So dividend paid out is now liable to tax at 10% for treaty 7.5. Then the tax is going to be final when you get it, is franked. The next one on this section 39 is what I've also explained that the reasons the limit is effective only to the line of business now, line of trade. It's not the trade that benefits. And Then I have the tax-free period must be certified by the Ministry of Petroleum before you can claim it. So I think we have a lot of cases before TAT on oil and gas, and of recent we are getting a lot of better understanding and good judgment that is helping us to even and to develop the tax practice. I really appreciate that, and I know as we are going on more and more, we get better. The PIB is in focus, and very soon. As last week, Thursday and Friday, we did the by cross consultation with the joint